We can see Ms. Rivers this time. Hey, Ms. Rivers, good morning. She's going to wave. Okay. You can hear us. That's good. All right. So back to the calendar. I think we can do everything we need to do. So Mr. Gatlin, good morning. Ms. Rios, is this your case?
Yes, Your Honor, I haven't had contact with him, so I'll go talk to him after the call.
Great. Mr. Gatlin, Ms. Rios is going to be representing you unless you're hiring your own attorney. Great. Then it's Ms. Rios, the one you just pointed at. I need to confirm your address. I've got an Emery Street address. Okay. You're going to want to give that to Ms. Rios. She can fill out a change of address. You can stay right there. She's going to meet with you after I call the calendar. She'll introduce herself. She'll get your good contact information. We'll get that into the system, and then we'll figure out what we're doing this morning, whether you're waiving arraignment or you want to be formally arraigned, and we'll move forward from there. So sit tight, and Ms. Rios will talk with you. Hey.
Asia Basic for the state, Your Honor. This is a domestic violence case, and I do see the defendant with someone in the gallery. I just wanted to make sure that that was not the listed victim, as there's a no contact order in place.
Well, let's find out. So, Mr. Gatlin, the other thing I typically do besides confirming address, and you told me you got a new one, so we'll get that into the system, is see how things are doing with your bond. And your bond that you received, it's a long time ago, but it's still your bond, in October of 24, said that you can have no contact with a Hannah Merritt.
Still no contact.
Okay, that's not Hannah Merritt sitting next to you. Excellent. All right. That's just, Ms. Beza is very wise and wanting to make sure. Sometimes we have, especially when this time has passed and this guy with his arm around someone, and it turns out like, oh, that's actually per Judge Oliver's orders. You needed to stay away from Ms. Merritt. And it sounds like you continue to do that, which is great. Okay. Well, you don't even need to get into it. I just needed to make sure that the young lady next to you was not Hannah Merritt, and it's not. So all good with that. If you'll take a seat again, Ms. Rios will chat with you and we'll figure out what's next with your case. Xavier Jones. Ms. Rios, your case also.
Yes, Your Honor, I have not had contact.
All right. And I think,
Good morning, Your Honor. Deputy Mill on behalf of the state. State will request a bond forfeiture bench warrant subject to good notice.
okay. This has a family violence battery count in it. Help me follow where it's going.
It's a domestic violence case, Your Honor.
Okay. Anything different than what
No, Your Honor.
Mr. Miller just said? Okay. All right, bench warrant. This case is sort of the same era, so I'm assuming there's good notice. We don't have a change of address, so I know notice went out to the address of record. So we'll treat that as a bench warrant. Ms. Beza, whoever you talked to yesterday got those bench warrants in lightning fast, so we'll do it the same way today. Thank you. Donald Gresham. Morning, Mr. Gresham. Mr. Gresham, I'm doing okay. How are you doing? Good. Do you have a lawyer? Uh-oh. Are you also Donald Gresham? Okay, I need you to take a seat. Mr. Gresham, do you have a lawyer? Do you need one appointed? Okay. Ms. Wood, I think this will be your matter. Have you met Mr. Gresham before?
No, but I was, I'll speak with him here.
Okay. Mr. Gresham, I'm going to have Ms. Wood talk with you about your case, and she'll introduce herself. She'll want to get contact information from you. You got something in the mail telling you to be here today? Great. Then it sounds like maybe the address. Well, I got two different addresses for you. One is on Valley View, and then we've got Wendell Court. Okay, well, what I'm gonna do is have Ms. Wood file a change of address form. I don't know how you're getting it. It's great that you're getting it, but the system says it's kicking things out to Valley View.
That view, that too, but like, when I was incarcerated, I had gave them the address that I was going to.
Okay,
They sent the mail to that.
great. I just want to make sure we've got it here as well. So I'll have Ms. Wood file a change of address for you that reflects whatever address you just mentioned that's not Valley View. All right, well, if you'll take a seat. Sir, the gentleman who stood up, if you could stand up again. You were waving a piece of paper. Did someone tell you to be here?
Yes, I wanted to talk to his lawyer.
Okay, you're free to do that. It may be that one of the prosecutors wants to talk to you as well. Mr. Miller, are you handling this today?
I will, Your Honor.
Okay, and what's your last name? Mr. Strong, you don't have to talk to anyone, but you came voluntarily, and so you certainly can talk with Ms. Wood. I bet she's gonna want to talk with you. Mr. Miller may want to talk with you as well, just to understand how you're doing and what you're feeling about the case. And it may be that we're able to do something with the case today. It may not, but I appreciate you being here. I hope you're doing okay. Okay. Trinice Lawton. Hello, Ms. Lawton. Good morning.
She is mine. I need to speak with her, but I do anticipate filing a waiver today.
Okay, Ms. Lawton, Ms. Wood needs to talk with you. Have you guys met before, or this will be your first meeting?
Well, yeah, it's face-to-face, but we'll talk with them.
Great. Well, you're going to meet face to face. Ms. Wood's going to chat with you some, and then she's going to let me know what we're doing today. But while I've got you talking with me, I'm going to do that whole address check thing. So, whoa, I've got a Miami, Florida address on 58th Street. Okay, so we've got a good address. Going forward, Ms. Lawton, unless we're doing something real substantive where there's going to be witness testimony and whatnot, it'll probably, emphasis on probably, be okay for you to appear on Zoom. So you don't have to come all the way from Miami. But you want to check with your lawyer each time to make sure she says you don't need to be here in person. You can get on the phone or computer or whatever. But there may be situations where we need you to be here in person. Okay, so we confirm the address. And then in terms of your bond, do you have children living in your household? 7?
Yes.
Okay. Are there other adults living in the household?
It just me and my dog.
Okay. All right. And are you working?
Yes.
What do you do?
I'm a should be right on the elements.
Okay. Excellent. That's what I needed to know. Ms. Wood will talk with you. Ms. McGillicuddy, is this a case under your, or is Ms. Patel? I don't know.
Your Honor, based
I
on.
don't get a lot of these cases.
Good morning, Your Honor. Based on the note in Odyssey, it indicates that this case is assigned to the Human Trafficking Unit.
Okay.
Yes.
Who is that prosecutor? I know.
Ms. Winfrey. Okay, great. It had Ms. Williams's name, but I think given the lead account, it would be Ms. Winfrey. So Ms. Wood, that's who you'll want to connect with, and we'll make sure Ms. Winfrey knows that Ms. Lawton was here today.
So announce who will be the ATM because we're doing scheduling over Zoom.
Yep. Will Ms. Winfrey be the prosecutor on the case going forward? Because the scheduling order that will flow from today will list a prosecutor.
I will say that it should have Ms. Winfrey as well as 88 Roderick Bridges as well.
Okay. Thank you. All right, Ms. Lawton, you can take a seat. Ms. Wood will talk with you, and she may say after you two have spoken that you're good to go. But don't leave until either she says it's good for you to leave or I tell you, all right? Thanks. Francisco Garcia.
Good morning, Your Honor. This is Eli Bennett speaking on behalf of Jerome Lee, the attorney of record in Mr. Perez Garcia's case. We are here for arraignment.
Great. And I see you. Do we have Mr. I think there's a Mr. Perez here.
That is my client, Your Honor. Yes, sir.
There he is. All right. And let's add you. and the courtroom. Okay. Mr. Bennett, good morning. Does Mr. Garcia need an interpreter?
He does not. Thank you for asking.
Great. Is Mr. Garcia waiving arraignment?
He is waiving formal arraignment, entering a plea of not guilty.
Okay. Have you filed a waiver? Or
We
you
did
will
not file a waiver. I've appeared to waive formal arraignment on the record. If the court requires us to file a waiver, I'd be happy to do so today.
I do, so you will. I appreciate you doing that. Let's see what's, yeah, Ms. Nelson will email you the form we use. You can just fill that out. I have an address for your client on Valley Court in Cumming, Georgia. Is that still a good address?
I can verify that, or I can ask Mr. Garcia. Just nod your head if it's still a good address.
Yes, it's a good address.
All right, a verbal nod. So we're good with the address. Then in terms of, so Mr. Bennett, I see in the docket that your firm has already filed a motion to suppress and general demurs and all these things before you even have any discovery, or we've been moving. Are those placeholder motions, or are those particularized substantive motions that I need to ask the state to take a look at?
Neither the demurrer nor the motion to suppress are particularized. I believe we also filed a motion for in-camera inspection of the alleged victim's therapy records based on the fact that the initial outcry in this case occurred during a therapy session. I'm going to reach out to the prosecutor and see whether we can resolve that without the court needing to get involved. And I would request at least 10 days post arraignment to particularize any motions once I've completed my review discovery. I don't think there's going to be any additional motions.
Okay. The way it works here is that you'll get more than that. There'll be a scheduling order that gets to you and the prosecution, and your deadline for filing particularized motions isn't until after the state's deadline to provide discovery, which is a little ways down the road. So that's all spelled out in the scheduling order. And we'll know, you just send courtesy copies to Ms. Nelson and to the state. That way we'll know if there are motions that need to be litigated before trial.
Understood. Yes, sir. I will do that.
Okay. Ms. McGillicuddy, good morning.
Hi, just letting Mr. Bennett know, I'm Deputy Caitlin McGillicuddy, and you can reach out to me with any communication. I'll get your contact information from ADA Williams.
Okay. Thank you, Ms. McGillicuddy. I appreciate that.
Yep.
Last thing we need to talk about is bond. It looks like bond was modified recently by Judge Manning. It's been modified a couple times. Let's see if we can get to the original one. Cannot read that handwriting. So Mr. Garcia had a curfew. It sounds like it's been modified some. What's your understanding, Mr. Bennett, as to where we are right now?
The curfew was modified to give him a chance to, his employment was a little bit later into the night than what was permitted. So I believe it was Judge Manning that modified that at the last ankle monitor compliance hearing. That was the purpose of the modification.
Okay, so Mr. Garcia is wearing an ankle monitor, and just a few weeks ago, Judge Manning said that the curfew is 9 p.m. to 7 a.m. That's when he needs to be home. That's your understanding?
It is, Your Honor.
Okay.
For night shift purposes.
Well, if the curfew is 9 p.m. to 7 a.m., that says to me he's at home from 9 p.m. to 7 a.m.
Oh, excuse me. Yeah, I got I got it reversed. I'm sorry. AM, PM. It all blends together, Judge. I apologize.
Okay, I hope it don't blend too much, but Mr. Garcia, tell me what you understand your curfew to be.
I can be at work from 7 a.m. to 9 p.m. Then from after 9 p.m. to 7 a.m. I need to be home.
Great. That's what I understand it as well. Okay. Ms. McGillicuddy, anything else from the state?
No, Judge. believe discovery was filed in this case on December 10th. So I can reach out to Mr. Bennett about anything that may be missing from that or supplemented.
Okay. It sounds like you should have discovery already, Mr. Bennett. Are you feeling like that's been provided?
It has. The only thing we need to discuss is I guess there's possibility of defects records that could contain relevant material to this case, as well as therapy records of the accusing witness that could contain relevant impeachment and or exculpatory evidence on behalf of my client. I'll reach out to Ms. McGillicuddy about that today.
Okay, excellent. And you'll fill out that waiver form and we'll go from there.
Yes, sir.
All right. That is it. Mr. Garcia, Mr. Bennett, you two are free to go.
Thank you, Judge.
Sir.
All right, bye-bye. Miranda Morrison.
And Judge, on this one, a waiver was filed. It looks like December 19th.
Okay. Yep. Who do you, I can't tell who well, let's see what the leave of absence says. Mr. Poole, okay. Did you have any contact with him?
I don't see the,
All right. I'm not going to consider it as a bench warrant right now because the waiver was filed. It sounds like there's a lawyer in place, et cetera. I don't know that we excuse them, but sometimes that's how people process. I filed a waiver, so I don't need to be here. Do you have any concerns based on your review of the state's file about Ms. Morrison's availability to come to court?
No, Judge. I think you're probably correct that I wouldn't ask for a bench warrant at this time, just based on the fact that a waiver was filed.
Okay.
I understand that's not the court's procedure, but more likely than not that he excused his client improperly, so I don't want her to get a bench warrant.
Okay. It looks like there was another lawyer, Katie Blackwell, who was involved, but she and a colleague of yours consented to her request to have the bond modified kind of recently. So it sounds like the case has been active with lawyer and client in the mix. So we'll leave it. And there's a waiver, so we'll get a scheduling order out. Thank you. Muslim Jones, I think you're online.
Yes, sir.
Oh, he is in custody? Ah, there he is. Got it. Okay, there he is. Hey, Mr. Jones.
How you doing, man?
I'm all right. Is Ms. Fagan your lawyer?
Yes, sir. Yes, sir.
All right. She is not here right now. Mr. Miller, this would be a case you're managing. Any info as to whether Ms. Fagan had contacted you or Ms. Smith?
No, Your Honor, but I will reach out to her after the calendar.
Okay, we'll reach out to Ms. Fagan. I'm gonna ask Oconee County to keep Mr. Jones right there for a little bit. We're gonna reach out to Mr. Jones's lawyer to see if she could hop on a Zoom, just so we could have the conversation we need to have.
medication, so she might not have been on the case.
Oh, it's not on for plea and arraignment. Got it. Oh, so let me see. Mr. Jones, when did you last talk to Ms. Fagan? She was in fact your lawyer way back in 2018. But she might not know about this case now. It's been a while.
Exactly. Yeah, I have not spoke to her since I took my time.
Since the time you took the plea?
Yes, sir. Yes, sir.
Okay. All right.
This was in 2019.
Okay. So I guess you could reach out to her to see if she is still expecting to handle the case, but if not, then we may need to reset this so that Ms. Wood can talk with Mr. Jones.
I'm happy to speak with him on the Zoom as well, Judge.
Okay. All right. So, Mr. Jones, we're going to try to contact Ms. Fagan to see if she's still your lawyer. You hired her way back when, and it could well be that.
Sorry, Ms. Simpson and I are communicating.
Yeah, this was gonna be a.
I'm happy to talk to him.
Simple, revocation.
Okay. I have a warrant for James and Harvey. Okay. Just got this one. Okay. So why don't we do that? We're almost done calling this calendar. And then what I'm going to do, Mr. Jones, is have you talk with Ms. Wood, who's a lawyer in here. And she can tell you a little bit about the case, and it may be pretty easy to sort this one out rather than bring everyone back in a month, only to learn that Ms. Fagan says, you hired me for the case way back then. You have not hired me for a revocation. Okay.
Yeah, because I'm kind of confused as to like what, because of course, I had first offender. I took first offender time, which was 25. I'm kind of confused as to like what's actually going on, because I'm actually on a like probation violation type of deal. Like I've already kind of like handled certain things in Cobb County. So what exactly is, I'm just trying to figure out what exactly is going on, like as far as like, so we're trying to figure out what's going on with this case again.
Okay, well, the petition that I signed and you signed it in November of this year, says that you violated your probation in September of this year in Cobb County by committing criminal damage to property in the second degree, disorderly conduct, and then there was a technical violation of not having obtained your GED. So the more serious one is you got arrested again and then you didn't get your GED. So I don't want to talk substantively about it right now. I want you to talk with Ms. Wood first to sort out what's going on. And then we'll see if we can do something this morning with the case, okay?
No problem. Thank you. I appreciate it.
All right. Marquita Brown should be in custody. I'm curious if this is really still ours. It has Ronnie Poole's name on it. I'm wondering if this should be a carnet sale situation.
Social work request and everything.
This was last on your calendars.
Well, I'll probably have to do an evaluation on her. So, I haven't seen her yet, but I'm gonna go talk to her. I did set aside orders, but they have nowhere to go.
Yeah, no, it's ours. Okay.
That's
Ms. Rios?
mine. I did file a motion to set aside the bench warrant. However, I'm gonna have a conversation with them. I think we need to hold off on that so we can get some services in place first.
Okay. It looked like she went to BHTC a long time ago, and then that didn't work. And so it came back to Judge Downs. And then Ms. Brown missed court in 2019, and there's been a bench warrant out there ever since. And I guess she's resurfaced now. So the original charge of aggravated assault is still out there. So it's an active case?
Yeah.
Okay. So you and Ms. Ross and others want to work with Ms. Brown to see if you can line up an opportunity for her to get services?
Yes.
And you'd like to have that happen with Ms. Brown in a known location, as in staying in custody?
I'm gonna talk to her. I just figured she needs the location before the bench warrant to decide, so.
She does.
But I just need to explain that to her.
Okay. Mr. Miller, are you the lawyer that Ms. Rios should be talking to about potentially resolving the case?
That's perfectly fine, Your Honor. It does has a designation that says aggravated assault, family violence.
Okay.
Okay, so we'll take it.
Okay. Ms. Rios, do you want to talk with Ms. Brown and then see if she should come out into court, or why don't we do that? So we'll hold on that. But it sounds like today it may just be introductions, and then we'll bring Ms. Brown back again when you've lined up some resources that might help with the bench warrant. They might help with just resolving the case,
Yes.
given its age. Let me see. So it's conduct that allegedly occurred 11 and a half years ago. So, okay. Yeah, hopefully we can work through that, but we certainly need something in place for Ms. Brown.
Yeah.
All right. Then we've got Angela Lewis, who I think is also in custody. She missed court, and that's you also, Ms. Rios.
Yes, Your Honor. That is a similar situation. Ms. Ross has also been to see her, so we're also trying to line up some services.
Okay. Do you want to talk with Ms. Lewis, and then we'll see if we'll talk as a group, but Ms. Lewis will probably stay where she is.
Yes, Your Honor.
All right. Thank you. Then we've got Billy Lowe, who should be in court, I think.
Yes, Your Honor. He was released before.
He could be evaluated. But Mr. Lowe's not raising his hand.
Haven't had contact with him.
Okay.
Your Honor, state will request a bond forfeiture bench warrant, subject to notice.
Okay. How did he get released?
He wasn't being held on this case. He was being held on like a misdemeanor situation. That situation resolved, and then he was released.
Got it. Okay. All right. So we'll do a bench warrant for Mr. Lowe, for Mr. Jones. And that's it for this calendar. Why don't we quickly call the final plea calendar to see what's happening with that? And then I know some lawyers need to talk to clients. We got to get you, Ms. Wood, on with Mr. Jones at Oconee. So final plea calendar. The first four positions, Bledsoe, Toussaint, Enriquez Perez, and Smart, those cases are all on the February trial calendar. If you do not resolve your case today, I'll see you on the 12th of next month when we call your case for trial. The last three cases, Nash, Davis, and Glass, are on that March calendar. So if you don't resolve your case today, it's actually a couple months before you'll be in here for trial. But the first one is Tyler Bledsoe. Is Mr. Bledsoe here? Morning, sir. Ms. Rios, what are we doing with Mr. Bledsoe?
That's going to be a plea this morning.
All right, we will do that. Mr. Bledsoe, if you'll take a seat, when we're ready for a plea, I'll get you up here with your lawyer and we'll take care of that. Janae Toussaint.
Morning, Your Honor.
Hey.
Here on that case. The prosecutor and I have been talking the last couple of days. I don't believe she's here this morning, so I'd like to keep talking to her. We're not in agreement yet on a plea, but I hope to get there pretty soon.
Okay, Mr. Miller is your man.
Okay, perfect.
So that's who you want to talk to. And if there's something we can do today, great. If not, we'll get on the record what the state's offer is and Ms. Toussaint's rejection of that. And then you still got a month to try to work things out.
Okay.
But we'll go to trial on that February trial calendar. So Ms. Toussaint, if you take a seat, your lawyer is going to talk some with Mr. Miller to see if maybe there is something that can be resolved. And if so, we'll take care of that today. Thanks. Jesus Enriquez Perez.
Ross Gordon here in that case, Judge. Good morning.
Hey, Mr. Gordon, how are you?
Good. I'm covering for Mr. Sperling today. I've spoken to the state. It's my understanding that they're pretty close to a resolution, but my client is currently in custody in California, and he's a lawyer that's working to get him released. So I was hoping we can continue this to another final plea calendar so we can get him out, bring him in, and get the case closed.
What is your forecast as to when Mr. Enriquez Perez will be out of custody in California?
So I know that his attorney is working on it. He's in an ICE facility, but he is engaged to a U.S. citizen, has a U.S. citizen trial, and I believe no other criminal history. So they're working on getting him a bond right now. I don't have like a for sure timetable, but we're hoping that they'll be able to get him out, relatively soon, because I think he's been there for about a month or two already.
Okay. You are powerfully optimistic about his chances with.
Judge, as a defense lawyer, we get paid to be powerfully optimistic.
Yeah. Okay. Well, I wish him the best on that front. I'm focused more on this case.
It's fine. Good morning, Judge.
Good morning. How are you?
Good. We are close to a resolution.
Okay.
I don't know if it's possible to zoom in, Mr. Perez. I'm not sure how ICE works that way. I know other federal facilities were able to. So if that's possible, maybe we could do it by Zoom.
Do it as in the resolution?
The resolution.
So he doesn't need to come all the way here?
Correct.
Okay. Mr. Gordon, we've done that before. It is more complicated on the federal side. They just don't make it quite as easy to connect as with state or local facilities. But it's a great idea in terms of resolving it more quickly and not requiring Mr. Enriquez Perez to travel all the way to Georgia. How regularly are you in contact with him?
We are regularly in contact, and Judge, just so the court's aware, he lives in Georgia. So if he's released, coming in isn't much of an issue. Just the Zoom will be helpful. If he's not released, we can still get the case closed.
Right. So I guess since he's not here today, we can't do the final plea, but my preference is to leave this case on the February trial calendar, preserve Mr. Enriquez Perez final plea rights, which means he could withdraw his plea if I sentence him to more than you ask for. But if it's negotiated, chances are higher that I'll be favorably influenced by what you all negotiated. And then we'll just need to work on establishing a Zoom link with whatever facility he's at. Do you have that information so you could share it with Ms. Nelson?
I do.
Okay, you don't need to do it right now, but we'll want to track that down. And what needs to be?
I can put it in the chat, Judge.
Great. What needs to be done to say, yes, it has been worked out?
I'm not sure. I think it's just on Mr. Perez's side, but we do have an offer that's been extended.
Got it. Okay. And Mr. Gordon, is it an offer that you've shared with Mr. Perez and he's thinking on it, or he said, yes, we just need to get everyone together, or where are we in that process?
I do not know, Judge. I know it's been communicated to his family. I do not know the extent at this time of communication to the client.
Okay. Well, that's a project for you and Mr. Sperling to communicate with him and see where he is. And if we can do it before the 12th of February, all the better, especially if it's a designated, we're going to do it at 1 p.m. My guess is that facility is not going to say anytime in the morning, but it will be, we will have him on a screen at time X. And so we'll work with the lawyer's schedules to make that happen. But he needs to say, yes, I want to do that first.
Yeah, understand.
Okay. Anything else from the state?
No.
All right, Mr. Gordon, anything else from the defense?
No, Judge, that concludes my business. May I be excused?
Almost. If Ms. Nelson or if I am reaching out to the lawyers on both sides to say what's going on, do we reach out to you or Mr. Sperling, or what's the right point of contact?
Mr. Sperling.
Okay. All right, then you're good to go. Thank you.
Thank you, Judge. Have a good one.
So, Ms. Patel, we should just keep you in the loop on this one. All right. Okay. Teresa Smart.
I'm a little bit confused
Okay.
because there is a entry of appearance from back in August of 2025 by attorney Sherry Lassiter. It looks like discovery was provided to her. Then there's a motion to withdraw by Scott Smith. I'm not sure. I don't see an entry from Scott Smith, so I'm not really sure, and it doesn't look like that motion was ever granted. And then there's a leave of absence from Sherry Lassiter again for this week.
All right. Of the Wade Law Firm. She did file the waiver of arraignment in the case, so maybe Mr. Smith was involved way back when. But I typically don't grant motions to withdraw just because it was filed. We need to have people in court so a defendant can say, I don't want that person anymore, or, yep, we've agreed to part ways. I have another entry. Let's see who this was. So Mr. Smith filed an entry of appearance in June of 24, pre-indictment, long ago. And before it was indicted, he filed a motion to withdraw. This would have been December of 24. But there's really no one tracking the case then, so no one would have ruled on that. Then in August of this past year, 25, Ms. Smart is indicted, and the very next day, Ms. Sherry Lassiter of the Wade Law Firm filed her entry of appearance. So I think she is counsel of record. We need to get Mr. Smith out. And then there is this leave that was filed that I need to look at. Okay. So I guess what we'll do is move this to the trial calendar, but preserve Ms. Smart's final plea rights. I didn't excuse Ms. Smart, but because her lawyer couldn't be here, it's possible that she said, you don't need to come to court because I won't be there. So I'm not thinking necessarily bench warrant, but it doesn't look like from the history of the case. It's sort of like the last case we were talking about.
Okay, Judge, the only thing that I have additional to add is that we have requested some medical records that we're waiting on, and we will supplement discovery to Ms. Lassiter, Sherry Lassiter.
Okay.
Once we have those.
All right.
That's my understanding item.
Any reason to think it will take a while to get those?
I don't believe it will.
Okay.
But we've requested them already, we're just waiting for them.
Okay, and Ms. Sherry Lassiter's leave does not conflict with the trial calendar. Well, I can't say that. It doesn't conflict with the calling of the calendar, which is the 12th. And the trial calendar isn't till the 23rd. She's got leave through the 24th. Okay. We'll work on contacting her to see, do you have any notes about this was close to working out, far from working out?
I don't judge, and I'm not sure that we've had good communication with Sherry Lassiter.
Okay.
But I will endeavor to continue to try.
Okay, we'll do the same. We'll keep it on the trial calendar, at least the call of the calendar, everyone can do based on her leaves, and we'll see what happens.
Actually, I believe that concludes my business. May I be excused?
Yes, ma'am.
Thank you.
Willie Nash.
Judge, he should be on the Zoom.
He is.
Perfect. I actually have an updated offer. I just need to call him and convey that.
Okay. Mr. Nash, can you hear us?
Yes, I can.
Great. Are you driving?
I'm sorry.
Are you driving?
I am driving. Yes.
Okay. So when we deal with your case later today, you need to be not driving while we're doing that. All right?
When is later today?
Well, it should be right now. You should be not driving right now, but you are. I'm gonna let it slide. Not safe for you or anyone around you. But I'm gonna have you talk with Ms. Wood. We're almost done calling these calendars. She has a new offer from the state that she wants to talk to you about. And when we talk again, because this is your final plea date, this is the last day for you to resolve your case. If you're going to resolve it short of trial, when you'd have the right to withdraw your plea if you were unhappy with the sentence that you got. But that involves a conversation that we have with you not driving your big truck. So you need to be prepared to be hands off the wheel, engine off in a little while this morning, okay?
All right. Do we have a specific time, or I'll be able to get that from Miss Woods?
Ms. Wood will talk to you more about that. She's going to call you in a little bit. Does she have your number?
She should. Yeah, we've been in contact.
Okay, sounds good. 10-4.
All right. Thank you. I'm good.
Don't go anywhere. She'll call you.
Okay. All right. Thank you.
Broderick Davis. Hey, Mr. Davis. I'm all right. Good morning.
That's going to be a plea this morning.
All right, Ms. Rios. So, Mr. Davis, in a little bit, we'll get you up here. We'll do Mr. Bledsoe first, but we'll take your plea as well. Okay? Mr. Glass? Hey, good morning. How do you pronounce your first name? DeQuavius Glass. Good morning. Ms. Rios, also your case.
Yes, Your Honor. I would ask for this to be reset. I just spoke with Mr. Miller. We're gonna put it on diversion.
Yes, Your Honor. I asked that this matter be reset for status. We're going to refer this matter to diversion.
Okay, so what I'll do is keep it on the March trial calendar, a couple months away. If between now and then, and this would be through the district attorney's diversion program or through a separate diversion program?
Through our program, Your Honor.
All right. And Ms. Rios, have you talked to Mr. Glass about this concept, or is he wondering what we're talking about?
He should be very happy.
Okay, he just smiled. Good. So Mr. Glass, I'm going to keep your case on this March trial calendar, but if before then you're accepted into the district attorney's diversion program, which is a great program that often has good outcomes for folks who do all the things they're supposed to do. If you get into that program, then we actually freeze your case put it somewhere else and give you the time, 6 months, 8 months, whatever seems reasonable, to complete all the work that you need to in diversion. And if you've done that by that deadline, then the state asks for your case to be dismissed. And I say, of course, and the charges go away. So it's a great opportunity, but you got to do the things that you commit to doing in the diversion program. Okay? Any questions about that? No? All right. Ms. Rios, do you need Mr. Glass to stick around?
No, Your Honor.
Mr. Miller, what is your best guess as to when we'll know if Mr. Glass is accepted into the program?
You know, I would think by the end of this month.
It would take 24 days to figure out?
No, that's just worst case scenario, but I would suspect maybe by the end of the week, hopefully.
Okay, I'm going to try for end of week, and we'll see. I may bug you and Ms. Rios early next week or something saying, hey, what's the deal with Mr. Glass? Mr. Glass, you don't need to worry about coming back to court unless you don't get into the diversion program. And then Ms. Rios will talk to you about whatever's next. Do you have any questions about anything? Did you get something in the mail telling you to be here today?
Well, yes, sir. Yes, sir. Not ready to start that.
Okay. All right. Ms. Rios, anything else in connection with Mr. Glass?
No, Your Honor.
Mr. Miller?
No, Your Honor.
All right. Do you need Mr. Glass to stick around?
No, please. Okay.
He's free to go. All right. Go have a good day.
Yes.
Yes.
Agree on one.
She said she was wrong. And then the other one, I'm not sure we talked about the URL date. I was gonna ask for one for, Roger Taylor.
So, whoop.
I'll go first offender, Alfred, please. It's both from the first, well, no, not, Bledsoe's not the first offender. Yeah.
I didn't see it. So, yeah, look at
Judge Taylor said we can have his jurors.
I haven't seen. I mean,
I'll ask probation just to double check. I know he doesn't have anything in Georgia, so he had something else.
Charles McCrary. Ms. Wood.
Yes.
We,
I need to speak to Mr. Miller about that. Yes, but I emailed Mr. Sperry yesterday, but I'm expecting some sort of resolution today.
okay, I think Mr. McCrary is a higher priority resolution for us.
That is correct, Your Honor.
Good.
I'm aware.
Good. Sheriff's Office has been
Yes.
laser focused on.
You're right.
He's here. I think all of the male inmates are still downstairs. Oh, now they're up. They're up. Okay, go team. Everyone's up. So if you talk with Mr. McCrary, if that's a plea, that would be great. And we'll just hold off on the revocations so that I know that people need to talk with their lawyers, et cetera. Is there anyone here who has a case and they didn't hear me call it? Hey, Mr. Webb.
Good morning. Your
Good morning.
We are here, as the court granted us the right to come to turn a client in today. That's wrong with him.
Yes, and he was here right on time. Deputy Gordon was just wanting to have other things happen, but he's been working with Mr. Jones. So thank you. Thank you for being here.
That includes my reason.
You may. Happy New Year. All right, anyone else? All right, lawyers, if you would talk with clients, et cetera. Ms. Wood, do you want to go into the jury room to connect? So Mr. Jones and Oconee, Ms. Wood, one of the public defenders here is going to hop on the Zoom. I'm going to move, once I see her on the Zoom, I'm going to move the two of you into a breakout room, which is a private space. No one else can see or hear you, so you guys can talk confidentially about what the state's or the probation's recommendation is, and you can let Ms. Wood know your thoughts, because I know you wanted to share something about, like, wait, I thought I dealt with the Cobb situation. You can speak with her freely about all that, okay?
Thank you. I appreciate it.
Right, I'll just talk to the two in the back and then one here, and then I'm ready on the police.
Okay, and if we can if I can facilitate with either of Ms. Brown or Ms. Lewis, that's great. It may be that you can, I don't need to talk to the judge, but if having the judge say X or Y or Z. Okay, I'm happy to do that. You should go talk with the lawyers. It's all good. Now is lawyer talking time.
Hey, how you doing? Good. Yeah, absolutely.
Hey, same.
And let me think that Jasmine. Right, but you can know their name. I don't. No. Yes, yours was good.
Mr. Joe, it worked. Great. All right. There we go. Hey, Mr. Jones, can you hear me? Great. I think we're going to handle your case now. Ms. Rivers, are you ready?
Yes, I'm ready.
Okay, we're going to go on the record in 18 SC 161490, State versus Jones. Mr. Jones is appearing from the Oconee County Jail. His lawyer, Ms. Wood, is here in court, and we have Ms. Beza for the state. And Mr. Jones, we are here because I signed a petition for a revocation or an adjudication of guilt in your case that alleges that in September, late September of last year, you committed the crime of criminal damage to property in the second degree, simple assault, and disorderly conduct in Cobb County, and also that you had failed to obtain your GED. Did you get a chance, Mr. Jones, to talk about this situation with Ms. Wood?
I did.
Okay, you comfortable going forward right now?
Yes, sir.
All right, Ms. Wood, is Mr. Jones admitting to these things, or what is his approach?
Yes, Judge, we are admitting to everything. We're in agreement with the state and probation to revoke 30 days and reinstate to probation and maintain his first offender status. He's actually already done 56 days in custody.
Okay, but the 30 days of revocation is prospective.
Oh, I forgot. So we need to.
My recommendation was reduce down judge because he took a plea to those charges and to a lesser offense of disorderly conduct.
So the whole Cobb thing reduced down to a disorderly plea.
And received homeless.
Okay, so he's on misdemeanor probation out of Cobb. He'll remain on felony probation for this case, because I think in your email you mentioned he's got 5.5 years left. Okay. If we were to revoke 30 days, I can't really give him credit for time served. So am I just revoking for the time he served, or how do we structure that on the revocation order?
For the of days.
Because I believe
It's 56.
Oh, it is. It's over 30 days. But if it's only 30, if I revoke for 30 days, can I give him credit for time served? I just don't want to run afoul of the.
Yeah,
you-
that should be fine, as long as, no.
If it's under 6 months, we're not running into issues. Okay, all right. Ms. Beza, you are even newer to this case than I am. Have you had a chance to look at any of the facts and circumstances around it?
I have, and I've spoken with 88 Miller, and the state is on board with the probation's recommendation.
Okay. Mr. Jones, do you have any questions or anything you want to add about your situation?
Sir,
When you get out, where do you go? Do you live in Cobb or Fulton?
primarily Atlanta.
Primarily what?
Atlanta.
Primarily Atlanta, as in Fulton County, Atlanta, or DeKalb, Atlanta?
I'm sorry, yeah, William County.
Okay. So I've got an address for you in Lithonia. That's probably not where you're staying because that's not in Atlanta.
No, sir.
Okay.
That was before the trial in 2019.
Okay, way back when.
Yes, sir.
All right. Well, Mr. Jones, based on your admissions, I find that you violated the terms and conditions of your probation by picking up this misdemeanor in Cobb County. And I will revoke 30 days of your probation, but give you credit for the time that you've already served. I will maintain your first offender status, only because the state's asking that we maintain it. And remind you that if you pick up a new situation, it can even be a misdemeanor arrest. It doesn't need to be a felony arrest. You run the risk of having your first offender status taken away, which will just mess things up for you. Not only could you be sentenced to a fair amount of time, you got over 5 years remaining, but you could be resentenced and it puts a felony on your history, and you've managed for 6-ish years to benefit from the first offender status. So I don't know what was going on September 30th in Cobb, but I hope you're able to avoid situations like that going forward. Are you working or were you working?
I was not at the time.
Okay.
I do have a couple.
Have you had a job since you entered this first offender plea back in 2018?
Yes, sir. Definitely.
What kind of work?
Well, when I first got out, I got a picking and packing job. I moved up pretty fast, like 6 or 7 months, to be a manager within the company. I ended up losing the job, honestly, on some blackball type of deal. I don't want to get too much into it, but I ended up getting another job not too long before. I actually ended up catching this little charge, and I just had a lot going on. Just unfortunate. Hopefully, I be better when I get back out. I got a couple things in place where I could, establish a foundation.
Okay, well, I hope that works out. Ms. Wood, anything else on behalf of Mr. Jones?
No, Judge, thank you.
You're welcome. Anything from the state? All right, what kind of information do you need, Ms. Simpson, from Mr. Jones?
We've gotten everything updated from Mr. Wood. He just needs to know that he's reported in 48 hours.
Okay, Mr. Jones, I don't know when you'll be released. It ought to be in the next day or so, in which case you've got 48 hours to report to probation. Do you know where to report?
In Fulton?
In Fulton. Do you know where in Fulton you go?
Sir.
Where's that?
I'm not sure what the establishment is called, but I know exactly where it's. I know where it's at. I forgot the name, but I know where the location is. It's somewhere. It's downtown, close to the courthouse.
Okay, it is close to the courthouse. So is Subway. Don't go to Subway. Go to the probation office. Okay.
Sir.
All right. If you've got everything you need, Ms. Simpson, then that's it. Thank you, Oconee County, for having Mr. Jones available.
Yes, sir. Thank you, Your Honor.
Thank you.
Thank you, Judge.
Thank you, Ms. Wood.
Thank you. Is he here?
All right. I don't see Ms. Rios. So I'm going to go back there. I'll come back out as soon as, is Mr. Miller handling anything else, or did you have all the pleas?
I have 3, please, Your Honor. He
Okay.
might have 1.
Okay.
And I know he has a probation vacation.
Okay, right. We hadn't called that calendar yet, but we'll certainly do that. Okay, well, we'll do the pleas once folks are ready. I'll come back out. All right, Ms. Rios, do we need to chat with Ms. Brown or Ms. Lewis?
Both.
Both, okay.
Both would like to go forward with setting aside bench warrants.
Oh.
But we can,
Okay. Do either of them have a place to go right now? That sounds to you, I mean, we'll get it on the record, but that sounds to you like a safe and stable place to be.
We're still trying to figure that out.
Okay. But, okay, all right.
I will say Miss Lewis has a home and a place in a location to go to. She just needs another caretaker, but she says she can apply through Social Security to get another one. But
She needs a caretaker for herself.
yes, but
Okay.
she's, one passed away, but she said she could just get another one. She also has 9 children, so maybe they can,
9.
yes.
Okay, all right. So Mr. Miller, Ms. Beza, which of you will be, we're going to talk about setting aside bench warrants for Ms. Brown, that's position 8 from the plea and arraignment calendar, and Ms. Lewis, position 9.
Your Honor, the state would object to a bench warrant being set aside for position 9, Ms. Lewis. It's my understanding that that case is still open.
Okay, I want to hear from both of you. They're both open. I'm going to bring them out here in a minute. I just wanted to know who I would be calling on to, you'll handle both?
Yes, Your Honor.
Okay, got it. All right. Well, let's start with Ms. Brown, please. And can Ms. Brown come to the podium, or would it be better if she's, no, she'll be right next to Ms. Rios. Okay.
Yes, she can. No, that's, yeah.
Yes.
The resolution for Christopher James.
Yes.
Yes.
This is Ms.
I'm
Brown.
gonna ask if we can possibly, revisit tomorrow, the violations that the officer stated on the petition are incorrect.
Oh.
The charges are incorrect. It says
Terroristic threats, possession of a firearm, and marijuana.
those are incorrect. His charges are aggravated assault and something bad.
Oh, wonder what happened.
I do not know, is the charges are shown as they are, on his GCIC as well. And that case is before Judge Leverage, and I need to get his officers to correct that as soon as possible.
But if there's an open indicted case that's the basis for the revocation, we should just send that to Judge Lethbridge.
First with me is no judge, he stated that he does have a bond hearing before her on this.
Okay. All right, well, we'll see. All right, we'll figure that out, but thank you for flagging that out.
And Your Honor, I would like to also speak with probation regarding Mr. James's matters. The alleged victim is present in court. So he did provide me with a statements and documentation to provide to probation.
Okay, got it. Well, we'll certainly touch it today. And it may be that he's willing to waive the defect in his, I don't have the petition. I'm assuming the petition says the same thing as the warrant.
If the warrant has a specific, yeah, it is.
Yeah, so that's the defect, is that the warrant and the petition say, hey, you're in trouble for doing X, and the officer just put the wrong set of crimes in there. But if everyone wants to work it out today, we can do that. So we'll see. I think it would be Ms. Wood. Both the numbers are in her range.
Okay, I will get with her.
Okay, all right. Well, let's talk with Ms. Brown. So we're going to get on the record now. This is 15 SC 131887, State versus Marquita Brown. Good morning, Ms. Brown. I'm Judge McBurney. I don't think we've met before.
No, we haven't.
Okay, I know you work with Judge Downs. Your case is older, but you, for a little while, were in behavioral health treatment court. That didn't work out. And then for a long time, we just couldn't find you. But then more recently, I guess you somehow bumped into the police, and there was this warrant that Judge Downs had signed many years ago, 2018, 2019, that popped up when you told the police, hey, I'm Ms. Brown, and you've now been in jail for about a month in connection with, maybe longer than a month. I'm not trying to shortchange you, but you've been in jail for a while in connection with that warrant. You've got a fairly serious charge, aggravated assault, but hold on, don't talk about the substance of it. But it's also real old, I get that, and time has passed. And so I think the real goal ultimately is to figure out a way to resolve this case, to get it off your back and everyone else's. But I don't know that we're in a position to do that today. And so what we're going to talk about is why you missed court, and hold on, you get a chance. Why you missed court, and then to me, almost as importantly, why should I not worry that it would happen again? In other words, how can I be sure that when we do get to your case, in through that door walks Ms. Brown, and not, we don't know where she went, okay? So I'm gonna let your lawyer start, and then if she thinks that it is a good idea for you to say things on the record, she'll certainly let you do that, okay? Ms. Rios, tell me what's going on with Ms. Brown and where you think we should head.
Yes, Your Honor. Ms. Brown is 54 years old. She's from Georgia. She states that she can find housing, that she has hotel options and things that she would be able to stay at, and that she would make sure she came to court. She did not know that she had a court date. I do have contact with her uncle, and hopefully by them communicating, possibly make sure she knows that she has court.
Okay. And Ms. Rios, have you had a chance to speak with Mr. Miller or Ms. Smith about how we might resolve this case, apart from the whole issue about bond?
Briefly, I think we can work something out relatively soon.
Okay. All right. But you are interested in identifying some services for Ms. Brown as part of the resolution?
Hopefully, she has stated to me that she would not like any services at this
Okay.
point. So,
Got it. Ms. Brown, I'm gonna ask you a few questions, and then if you want to share some things, you may want to tell Ms. Rios first. So the address I have for you in the system, I have a couple. One was on Westlake Avenue, and another is Old Atlanta Station Court.
And that's the one I said. That's what I was saying. I'm gonna tell you, one of my brothers, okay, Alfonso have 5 brothers, right? Me and Alfonso, he's the one who raised him. That's what I was trying to tell you.
Alfonso is, who is Alfonso to you?
That's the baby boy. He's the one who raised.
Okay.
Our other uncle is the one who pushed me down some stairs and broke my leg.
Ouch.
See, that's what I'm saying. At that house, and he wanted. Me and Alfonso said no to it. He got me with me and Alfonso. His name is Arthur Hope. He's the one who did that assault to me.
Okay.
Alfonso disputed it. He walked away. I work in healthcare. Okay. I'm so sorry. I work in healthcare, Your Honor. So I take my healthcare expertise. I take it serious. God had put a degree in my hand for me to play around and drink and smoke. So Arthur is the one who had that house. He got married with me and Alfonso.
When did you last work in healthcare?
I still do, every now.
Okay.
Alfonso said, Marquita, keep your nose clean. No drugs, no alcohol. Arthur got married with Alfonso, and we both left. We left him up at the house. He the one got grandchildren and a child. I don't have any children.
Okay.
Alfonso talked to me very firmly. He talked to me very well. He's a firm, strict doer. Do it, Marquita, get it done.
And Alfonso, what's his last name?
His name is Holt.
Holt. So Mr. Holt, he's the gentleman who lives at the Old Atlantic Station
That's
Court?
where I stay.
Okay.
Now, I'm telling you what Arthur did. He
Well, I don't-
put a bill in my name.
Okay, we shouldn't get into Arthur right now. I need to explain to you the case that you picked up. The name of the supposed victim is Latasha Tarver.
I don't know them. That's what
Okay,
I'm saying.
okay, but I'm just letting you know it's not, you mentioned Arthur's the one who assaulted you and not the other way around. Arthur's name isn't anywhere in this indictment.
I know, I was telling you what happened at the house.
Got it.
So Alfonso and myself, we never turned back. Their mother had passed. He got upset with me and Alfonso both.
Okay.
I told Alfonso and myself, for Arthur not to come to Marietta because he's violent.
Okay. Now Marietta is different from this old Atlantic.
It's off Car Parkway.
Okay, it just happens to be an Atlanta address.
Yeah, it's like Chattahoochee, it's like Midway both.
Got it.
It's like, the river is right here.
Yep.
Car Parkway is like on the right-hand side.
Yeah.
And it's like the mixture of Chattahoochee, it's on the verge of Atlanta and Car.
Okay, got it.
Too far from the mall.
Okay,
So I've been staying there with him. I've been on a narrow and straight line, no alcohol, I don't smoke and I don't drink. I went into healthcare at the age of 28. I wanted better. I never wanted to move to Atlanta. I never. So now, you know where I work still? I still work in healthcare.
okay. What kind of work do you do?
I sterilize instruments in dentistry,
Okay.
assist. And I can name the 4 doctors I work for. There was Dr. Phil, Dr. Thomas, Dr. Constance Rowan, and once.
Okay,
And I still do it. And I come to work every day, drug-free, alcohol-free. I get it and I get it done.
all right. Tell me, Ms. Brown, why you are reluctant. One of the things Ms. Rios is trying to do is to line up some support for you. And she's saying you aren't particularly interested in it. Is it because you think you don't need support or you already have it?
Well, my uncle is a great guy for me.
Okay, this is Alfonso?
Yes, he
Okay.
doesn't do anything. He's just like me. Pay bills, go to work, and get it done.
Okay,
Now, I don't fool with Arthur. Arthur is the devil.
okay,
He's the devil. He got mad. He threatened me and Alfonso. So
Okay.
I told to alleviate, to escalate it from getting me and Alfonso, we did. We hauled butt. We went to there. I'm gonna come up. And I said, don't come up there.
yeah. Okay,
In good space. He pays his part, I pays mine, and we get along well.
who else lives at that address in,
In Marietta?
yeah,
It's just me and Alfonso.
just the two of you?
Yeah.
Okay, all right. So, I'd like to hear from, the prosecutor.
Yes, Your Honor, it appears that this matter, incident stemmed from a 2014 incident date regarding the rooming house, regarding an aggravated assault in which a mug was used to strike Ms. Tarver in the face. She did also indicate that she swung in defense, and officers had indicated in the report that both parties needed stitches as a result of the incident. Given the length of time that has passed since the incident date, the state is offering a probated offer on this case. We would like some types of services for Ms. Brown. However, we understand that she can refuse those. However, should she enter a plea today, the state would recommend some form of services for her as a condition of probation.
Okay, all right. Ms. Brown, we have a couple things we need to work through. One of them is, what are we gonna do about bond? I'm gonna tell you about that in a minute. But we also need to deal with your case. It's not going away. It's old, and you just heard what the prosecutor said. No one's looking for jail time. They just want.
It's some jail time though, when they happen to deal with Arthur, that's what I'm saying. And I scratched it off. I never go his way.
Yep.
And I don't want him coming mine because he's the devil.
Okay, but you're talking about the situation with Arthur.
Yeah.
And I'm not, you may well have done some jail time in connection with Arthur's situation. I'm talking about this case from way back in 2014. Has nothing to do with Arthur. That's what we need to, it's why you got into behavioral health treatment court, and we're working with Judge Downs and all that. This was a minute ago. Arthur is more recent, and Arthur.
It was dead. It was dead.
Okay.
It was him. That's all I'm saying.
Okay.
Yeah, I hear him, but it's time for me to talk now.
Okay.
I don't hold some stuff. No, it's time for me to talk now.
Okay.
Because Arthur is a very, very.
I get it, but this is about Arthur.
I know it's not, but it's about me. I'm telling you what happened. I never got a chance.
Tell me, let me ask this question. The situation with Arthur being the devil and being rough, was that last week, last month, last July?
For years, it was like some years ago, and it was about a house.
Okay. But some years ago, was it 5 years ago? Was it?
About 7.
Okay.
Yeah.
All right.
I had just started in healthcare, and I had just gotten a job, and he came to church and wanted me to move into, and I told him, no, I'm not gonna move in Atlanta.
Okay.
So me and Alfonso made a better, deal, and he got mad with both of us, but he pushed me down some stairs.
When's the last time you saw Arthur?
I haven't seen him, sir. When the court told me to stay around him, I did it.
Excellent.
I never went his way. I have not got in trouble since I saw him. I have not went to church. I have not even thought of him.
Okay, well, good. Then Arthur's not an issue. We don't need to worry about it. He's out of the picture.
Changed my life. I go to North Springs up there to a NA class, a NA class, and I go to an alcohol anonymous class. And that's just to build my character up.
Good.
So I can stay away from drugs, alcohol.
So here's what I'm going to do, Ms. Brown. One of these will happen first. I don't know which one will happen first. Some of it depends on what you can do. Some of it depends on what Ms. Rios is going to do. Either we're going to get back together and talk about resolving your case, where it would be you're going to be on probation for a little while. And based on the good things you're doing for yourself, I'd probably just say, hey, part of probation is that you continue going to AA meetings. And maybe we'll do, you tell me, look, I do 2 a week, I do 2 a month. I'll say, great, you need to keep doing it. That's part of your probation. Not a new set of meetings. You go to that comfortable place where people know you and you know people. We'll keep that up. It may be that you have a random drug screen or something. That's the kind of support we're talking about. It's not, we're going to move you to Macon and you have to go to this program or that. It would be to maintain this good routine you have. And I hope you'll talk with Ms. Rios about that, because it sounds like that's the kind of thing the state is willing to offer. So either we're going to resolve the case that way, we can do it today, or you are going to need to get Alfonso down here so I can meet him and talk to him and understand that he can provide you with that safe and stable place that you described. So whichever one we can do first. So you may want to talk with Ms. Rios a little bit more, because it sounds like Mr. Miller, that's the gentleman who just stood up and said, look, it's old, we'll do probation, but we want some programming. You've got the programming. It's what you're doing. And so if you can share with Ms. Rios, look, I do AA meetings twice a month, twice a week, whatever it is, and I do this, then we'll make those the programming that you get. Okay, well, I'm gonna have you guys talk about that a little bit more, and then either we can work the case out, or you can figure out how to get Mr. Holt down here, and then I'll get to ask him some questions about the situation, okay? So I'm gonna have the deputy take you back, but keep you up here so you and Ms. Rios can talk a little bit more about the good programming you're already doing. Okay? Excellent. Thank you. Ms. Rios, before we bring Ms. Lewis out, is this a case where you and Mr. Miller talked about resolving it, and then you talked to Ms. Lewis about it, or it never got to that point? Were you
It
sitting over
hasn't
there?
got to the point where we're resolving for Ms. Lewis.
Correct. We're pivoting to Ms. Lewis now.
No, we have not talked about resolving.
Hers was just, I want to get out.
Yes, and that she can go back because she does have an actual address.
Okay. But they're two sides. She missed court, et cetera. So we'll work through that. All right. We'll bring her out in just a second.
Yes, and Your Honor, if I just had a moment to speak with probation regarding Ms. Lewis's case, and I can provide defense counsel with an offer on that, I believe we can resolve it today.
Oh, Ms. Lewis, the person who has not come out yet.
Yes.
Oh, okay. Well, why don't you guys talk first before I don't want to bring Ms. Lewis out and have her get exercised about something when maybe we can resolve it, which gets her home anyway.
All right.
Okay. So why don't we do then one of the pleas?
Let's do Mr. Bledsoe.
Okay, Mr. Bledsoe, come on up. And Ms. Beza, the way it helps Ms. Rivers, who's taking it down, is if you can be seated at the witness stand. All right, excellent. Let me know when you're ready.
I'm ready.
Got an issue. So there, okay. That's okay. All right, let's get on the, but if you'll bend the microphone down, that way Ms. Rivers will be able to hear you. This is 25 SC 004677, State versus Tyler Bledsoe. Mr. Bledsoe is here in court with his lawyer, Ms. Rios. We have Ms. Beza representing the state. And Mr. Bledsoe, it's my understanding that you are ready to enter a plea in your case. Is that right?
Yes, sir.
The way this will work is that in a moment, Ms. Beza is going to put you under oath and then ask you a bunch of questions about your case and your rights, et cetera. You need to answer her questions truthfully and completely. You also need to let me know if at any point you've got a question or you're just not following whatever's going on. Will you do that?
Yes, sir.
Okay. Ms. Beza?
Thank you, Your Honor. Please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
You may put your hand down. Can you please state your correct and legal name?
Tyler Jamar Bledsoe.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No.
How old are you and how far have you gone in school?
40 years old and completed technical school.
Are you able to read, write, and understand the English language?
Yes.
Do you understand that you are charged with the following offenses? Count 1, aggravated assault, and count 2, false imprisonment.
Yes.
Do you understand that you have the right to plead either guilty or not guilty to the reduced charge of count 1, which is battery, family violence, and count 2, false imprisonment? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes.
Do you need more time to discuss this with your attorney?
No.
Are you satisfied with her services?
Yes.
Counsel, do you waive formal reading of the indictment?
Yes.
Counsel, do you waive any and all defects in the indictment for purposes of this plea?
Yes.
Currently, the state is unaware of any outstanding warrants related to these charges. Do you, counsel, or do you, Mr. Bledsoe, know of any outstanding warrants related to these charges?
No.
No.
Mr. Bledsoe, has your attorney advised you of the minimum and maximum sentence for each charge that you are pleading to?
Yes.
For count 1, as you're pleading to misdemeanor battery family violence, the minimum is 1 day, maximum 12 months. For count 2, false imprisonment, and minimum is 1 year, maximum 10 years. Do you understand that?
Yes.
Do you understand that this is a negotiated plea of guilty, which means the state will recommend to the court a sentence of 2 years probation. While on probation, you are to complete the family violence intervention program, have no contact with the listed victim in this case, complete 60 hours of community service, and seek and maintain gainful employment. But the court does not have to accept this recommendation. The court can sentence you to the maximum on each charge. Do you understand that?
Yes.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as in other jurisdictions, including federal court?
Yes.
You understand that if you are currently on probation or parole, your probation or parole may be revoked based on you entering a guilty plea?
Yes.
Do you understand that if you're placed on probation of any kind, which you will be placed on probation, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes.
You understand that you are not allowed to possess or use a firearm while on probation?
Yes.
Are you a United States citizen?
Yes.
You understand that if you are not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at a trial would. And that is true regardless of any advice by your attorney or anyone else.
Yes.
You understand that neither the court, your attorney, nor the district attorney's office has anything to do with parole, the Department of Corrections, or Board of Pardons and Parole, and no one can guarantee that to you.
Yes.
You understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial. For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes.
Do you understand that if you went to trial, you would have the right to trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or to remain silent and not incriminate yourself?
Yes.
You understand that by pleading guilty, you are giving up the following rights. I'm going to list them. You're giving up the right to trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after trial.
Yes.
Has anyone forced you, threatened you, or promised you anything to get you to enter a guilty plea?
No.
How do you plead to the charge of count 1, reduction to misdemeanor battery family violence, OCGA 16-5-23.1?
Guilty by Alfred.
And how do you plead to counts 2, false imprisonment?
Guilty by Alfred.
Are you pleading guilty because you have decided that it is in your best interest to do so?
Yes.
Are you aware that even if you do not admit guilt, this is a plea of guilty and places you in the same position as if you were convicted by a jury at a trial?
Yes.
Now, is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
You understand that you do not have a right to appeal directly from your guilty plea, but if you believe there is some error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal. Understand that?
Yes.
Discretionary appeal procedures outlined in OCGA 5635 and must be completed within 30 days of today. Do you understand that?
Yes.
Now, Your Honor, as to the defendant's criminal history, I do not see any felony convictions from the state of Georgia, which is what I have access to. In addition, if this case would have gone to trial, the state would have expected its evidence to show that the defendant, victim in this case, Ms. Keiana, Keiana Walton, were boyfriend and girlfriend and lived together in an apartment. On June 29th, 2025, officers responded to the incident location, their shared home. Upon arrival, the defendant told officers everything was fine. They only had an argument. Officers ended up speaking with the listed victim in this case, who stated she and the defendant got into an argument. He grabbed her by the neck with both hands and began to strangle her. When she woke up, she called 911. She tried to leave the residence after calling, but the defendant told her that he would hurt her if she tried to leave. In addition, and backing up a little bit, when officers responded to the incident location, they actually heard a female screaming, "He's hurting me, come and help me." The listed victim in this case does not want contact with the defendant, and that is all from the state.
All right. And have you or has a colleague from your office communicated to Ms. Walton how this case might work out?
Yes, Your Honor.
Okay. Good morning, Ms. Jackson. Happy New Year.
Good morning, Your Honor. Happy New Year to you.
Do you have any criminal history information on Mr. Bledsoe?
Yes, there are 3 cycles. His last arrest was August the 27th, 2023 out of Roswell, Georgia, for a DUI and a hit and run. Those charges, the DUI was amended to a non-fingerprintable offense, and I think the hit and run was dismissed. He does appear to have an felony conviction out of Virginia. It was a 2007 case for possession of marijuana with the intent to distribute. And there appears to be an old outstanding hold out of Virginia where he failure to appear. The date on that warrant was October the 19th, 2023. Nothing in addition, Your Honor.
Thank you. Ms. Rios?
Yes, Your Honor. Mr. Bledsoe is 40 years old. He works for UPS Data Center and Talent Corps, or is it through Talent Corps?
It's through talent.
Through Talent Corps, and he did provide with me proof of employment. And he completed trade school, and he has 3 children, ages 10, 4, and 2. He doesn't have any children with the victim, is my understanding. I'm asking for a behavioral incident date of 1 year. He does not have a history of any violent charges. He's employed, he's doing well, he's just taking care of his children, and he would just like to put this behind him.
Okay. And you're not seeking first offender?
I think they said they had a conviction, so
That's what I'm hearing from Ms. Jackson. And so my inclination would be to not do this as a first offender, but if you are able to provide proof that the Virginia situation is something other than a felony, we could always amend it. But Ms. Jackson's read of the NCIC is that there is a felony. It's just out of state. And Ms. Beza was clear, I can only see into Georgia, and the Georgia criminal history, it sounds like, is pretty darn limited. Maybe there was a DUI that got reduced to something else, and then there's this situation. But it's still an Alford plea.
yes.
And tell me why it's an Alford plea.
He's saying it did not happen that way, that he was not, he could have probably explained it a little bit better, but that he was not stopping her from calling the police. There was no choke. Two sides to every story.
Yep.
That's not how it
Okay.
works.
Not that I wasn't there or we were just playing backgammon and it was a fun night. Yeah, we had an argument. It just didn't play out the way that Ms. Walton said it played out. Okay. Thank you. Mr. Bledsoe, the work you do at this UPS data center, it sounds like it's through a staffing company?
Yes, it's through a staffing company. I'm a systems engineer at the Windward Data Center.
Okay. How long have you been doing that?
I've been there for almost a year now.
All right. And before that, what kind of work did you do?
Before that, I'm a commercial HVAC technician, so I've been doing that for at least 8 years now.
Okay. Do you still do that on the side also, or you've left that behind?
Friends and family, but I'm mainly focusing on doing the system engineer work, and that's why I was going to ask with the probation if the travel not be limited, because I have to travel in order to train to become level 2 for the company that I'm with now. So that's the only thing that I'm asking, Your Honor.
Okay. The technical school, was that for system engineering or was that for HVAC?
That was for HVAC.
Okay. Do you have 3 kids? Do any of them stay with you?
No, they're all in Virginia, and that was going to be another reason I need travel. They haven't been able to come visit me since the incident, and that's completely fine. I understand, but again, in order for me to see them, I need to travel to Virginia.
Okay. Are they all in one place or are they in different places in Virginia?
All in one home.
Okay. Do you have any questions about anything we've discussed?
No.
All right. Well, Mr. Bledsoe, I find there's a factual basis for your plea. Ms. Rios has helped me understand that if this were a trial, it might come down to, does the jury credit Ms. Walton's description of the events more so than yours? But you're deciding that it's in your best interest, this is the Alford part of the plea, to take this opportunity rather than run the risk of going to trial and a jury concludes that Ms. Walton provided the more credible version of events, and then it would be a messier situation for you. Is that a fair summary?
Yes.
Okay, then I'll accept your plea. I find that plea is knowing and voluntary, meaning you've understood what we talked about. You told me you don't have any questions. Voluntary means no one's forcing you to do this. Ms. Rios, can someone in my office electronically sign the indictment for you?
Yes, Your Honor.
Ms. Beza?
Yes, Your Honor.
And Mr. Bledsoe, can we electronically sign your name to the indictment indicating your plea to count 1 reduced to a misdemeanor and count 2 as is?
Yes.
All right, we'll do that. I will follow the negotiated plea, and on count 1, sentence you to 12 months, count 2 to 2 years. Those will run concurrently with each other. I got to find the calendar I was working up. There it is. They will be probated. Special condition of probation number 1, the most important one, is no contact with Ms. Walton. That means you don't call her, you don't write her, you don't post something on her Instagram. You also don't do that indirectly. You guys may have shared friends, and you should not, through a shared friend, say, hey, how's she doing? Or let her know if I see her again, I'm gonna break her nose. Nothing good, nothing bad, nothing at all. Better for you, and it's what she's asked for, and most importantly, it's a condition of your sentence. So leave her alone. Number two, you're going to need to complete the Family Violence Intervention Program. That's not one class, it's a series of classes. It'll take a while to complete. You'll need to also complete 60 hours of community service. I will set a behavioral incentive date of January 7th, 2027. It's a year from now. If you have successfully completed the Family Violence Intervention Program, knocked out your community service, then if everything's gone smoothly, probation can say, why do we waste our time with Mr. Bledsoe? We've got people who are a real hassle to monitor, and Mr. Bledsoe is a model probationer. And if they want to end things early, they can do that. In terms of traveling out of state, you are not prohibited from doing that, but you need to seek permission in advance. You need to live in Georgia while you're on probation here. But if you know that you're going to go see your kids, and you know that's going to be May 15th through the 20th, you can ask probation, show them, here's my itinerary, or I'm driving, whatever it is. They'll check with me, and I just ask them, how's he been doing? And if they say there are no problems and he's already started FFIP, and I say, great, let him go. If they say he's tested positive for drugs, he's not showing up, then I'll say, no, he can't go. But you do need to get permission before you go. That addresses family. Your work thing, if you need to go every other day out of state, that's not going to work. Probation can't be authorizing these like every week I'm having to go here or there.
No,
if you need to go once or twice for a very discrete, I'm going to training and it's in Salt Lake City and it's from this date to that date, we can make that happen. Again, assuming you're doing all the things you need to do on probation. The key is simply let people know in advance. And advance isn't, I'm at the airport and the flight leaves in 5 minutes. Advance would be next week or 2 weeks from now, I need to go out of town. I'd like to go out of town, because that gives probation a chance to reach out to me, or decide on their own, we'll authorize that out-of-state travel. Does that make sense?
Yes, sir.
Okay. Do you live in Fulton County?
Yes, Sandy Springs.
Okay. Then I think I've covered everything I've got. Ms. Beza, anything else from the state?
No, Your Honor.
Ms. Rios, anything else on behalf of Mr. Bledsoe? Ms. Simpson is with probation. She will not be your probation officer, but she's going to need to talk to you a little bit. I'm going to have her do that right outside so we can move on with the next thing we need to do. Once you finish speaking with Ms. Simpson, if you don't have any other questions for Ms. Rios, you're good to go.
No, thank you.
Okay. Good luck.
Thank you.
Can we carry Mr. Davis next so we can do his plea before I talk to Ms. Lewis?
Sure, we can do that. Is that also your situation,
Yes,
Ms.
Your
Beza?
Honor.
All right. Position 6.
Position 2, we have a plea as well.
Great. We'll do that this morning. And is that with Mr. Miller?
Mr. Miller, yeah.
Okay. Are we ready on Mr. Davis, or you need a second?
I'm ready.
Okay. This is position 6 on our calendar. State versus Broderick Davis Jr., 25 SC 005028. Mr. Davis, you just watched a plea, so you kind of know how this is going to flow. Same process for you. You'll get sworn in, you'll be asked a whole bunch of questions. I need you to let me know if at any point you've got a question. Will you do that?
Yes, sir.
Okay. Ms. Beza?
Can you please raise your right hand? Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
You may put your hand down. Can you please state your name for the record?
Broderick Darcell Davis Jr.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No.
How old are you and how far have you gone in school?
I'm 22 years old and I graduated high school.
Are you able to read, write, and understand the English language?
Yes.
You understand that you're charged with the following offenses. Count 1, burglary in the first degree. And count 2, aggravated assault by strangulation.
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
I do.
Have you had enough time to speak with your attorney about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
I have.
Do you need more time to discuss this case with your attorney?
No.
Are you satisfied with her services?
Yes.
Counsel, do you waive formal reading of the indictment?
Yes.
Counsel, do you waive any and all defects in the indictment for purposes of this plea?
Yes.
Currently, the state is unaware of any outstanding warrants related to these charges. Do you, counsel, or you, Mr. Davis, know of any outstanding warrants related to these charges?
No.
Has your attorney advised you of the minimum and maximum sentence for each charge that you're pleading to?
Yes.
For count 1, the minimum is 1 year, maximum 20. And for count 2, as it is a family violence aggravated assault, the minimum is 3 years, maximum 20. Do you understand that?
Yes, ma'am.
Do you understand that this is a negotiated plea of guilty, which means the state will recommend to the court a sentence of 4 years probation, complete the family violence intervention program, complete 60 hours of community service, no weapons, seek and retain gainful employment, and no contact with the listed victim in this case. Your Honor, the listed victim and the defendant do have children in common, and they currently are using a third party for the children to go back and forth. The listed victim in this case wishes to leave it this way. So she would like no contact, but for their current third party exchange.
1 kid or several kids?
2.
2 kids.
Yes.
All right.
Now, do you understand that that is a recommendation to the court? But the court does not have to accept that recommendation. The court can sentence you to the maximum on each charge. Do you understand that?
Yes.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including federal courts?
Yes.
Do you understand that if you are on probation or parole, your probation or parole may be revoked based on you entering a guilty plea today?
Yes.
Do you understand that if you are placed on probation of any kind, which you will be, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of your sentence?
Okay. Yes, that's fine.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes,
Are you a United States citizen?
I am.
Do you understand that if you were not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at a trial would, and that is true regardless of any advice from your attorney?
Yes.
You understand that neither the court, your attorney, nor the district attorney's office has anything to do with parole, the Department of Corrections, or Board of Pardons and Parole, and no one can guarantee that to you.
Yes, I understand.
You understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial. For
Yes.
example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes.
Are you asking to be treated as a first offender under the provisions of the First Offender Act?
I am.
Have you ever pleaded guilty or nolo contendere to, or ever been convicted of a felony in the state of Georgia or any other jurisdiction?
No.
Have you ever been sentenced for any crime, felony or misdemeanor, under the First Offender Act?
No.
Has your lawyer explained the First Offender Act to you?
Yes, ma'am.
Do you understand that if you violate the terms of your first offender sentence or commit a new offense while on first offender probation, your first offender status could be revoked, you could be adjudicated guilty, and you could be resentenced up to the maximum sentence for each charge in this indictment?
Yes, ma'am, I understand it.
And do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes.
You understand that if you went to trial, you would have the right to trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or to remain silent and not incriminate yourself.
Yes, ma'am. Yes.
Now, do you understand that by pleading guilty, you are giving up the following rights? And I'm going to list them. You're giving up the right to trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Has anyone forced you, threatened you, or promised you anything to get you to enter a guilty plea?
No.
How do you plead to count 1, burglary in the first degree?
Guilty by Alfred.
How do you plead to count 2, aggravated assault, strangulation, family violence?
Guilty by Alfred.
Are you pleading guilty because you have decided that it is in your best interest to do so?
Yes.
Are you aware that even if you do not admit guilt, this is a plea of guilty and places you in the same position as if you were convicted by a jury at a trial?
Yes, I do understand.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
You understand that you do not have a right to appeal directly from your guilty plea, but if you believe there is some error in your guilty plea, you can apply to appropriate appellate court to request a discretionary appeal?
Okay, yes.
And do you understand that the discretionary appeal procedure is outlined in OCGA 5635 and must be completed within 30 days of today?
Yes.
As to Mr. Davis's criminal history, Your Honor, I do not have any felony convictions out of the state of Georgia. In addition, if this case would have gone to trial, the state would expected its evidence to show that the defendant and the victim in this case, Marlene Hernandez Alvarez, share 2 children in common. On the day of the incident, which is August 2nd of 2023, the defendant came to Ms. Hernandez Alvarez's home. She lived with her sister, Jasmine, at the time, as well as Jasmine's 6 juvenile children. The defendant came over and demanded to come in and take the baby from the victim in this case, their shared child in common. The victim told him he could not have the baby and that he could not come inside. The defendant made forced entry into the home through a screen door. The evidence would have showed that he tried to take the baby out of the victim's arms. She gave the baby to Kimberly, which is a friend that was also there. Kimberly stayed in the back room with the baby and the children. The defendant then placed both of his hands around the victim's neck and squeezed for approximately 15 to 30 seconds. Officers did observe fresh marks and bruising on both sides of her neck. She declined medical attention. That is all from the state.
All right, thank you. Ms. Jackson, do you have any criminal history information on Mr. Davis?
There are 2 cycles. The last arrest was June the 22nd, 2024 out of Hateville, Georgia, for battery, family violence, and 5 counts of cruelty to children in the 3rd degree. He was not prosecuted. The date on that was August the 15th, 2025. Nothing in addition, Your Honor.
Thank you so much. Ms. Beza, you wouldn't have any idea if that non-prosecuted case involved the same victim?
I'll look it up right now, Your Honor.
Okay, if you can, that'd be great. Ms. Rios.
Yes, Your Honor. Mr. Davis is 22 years old. He was working at a warehouse, but he lost that job. Right now, he's working at DoorDash. This convictions, well, not convictions, but these charges being on his record has made it hard for him to have employment. He was actually doing DoorDash under his another person's information because he's trying to be able to work to support his 4 children. He has a 2-year-old son and 2 one-year-old daughters. So I'm asking that you accept the plea under first offender and give him a behavioral incident date. And if you're inclined to do so, seal on the front end because he's saying he's having such a hard time working and he wants to be able to provide for his children.
Okay.
As to Your Honor's question, I do not even see that case in our system. It may be sealed.
Okay.
The state obviously leaves it in the discretion of the court, but the state would object to sealing on the front
Okay.
of the protective order.
I don't know if we mentioned earlier, but we did agree to the 2-year behavioral incident date, I believe.
Yes, the 2-year behavioral penalty.
Tell me, I don't want to mess up a protective order, meaning there is one in place, or basically this sentence is going to constitute a protective order because one of the conditions most certainly will be no contact with Ms. Hernandez Alvarez.
That is correct. This sentence would constitute a protective order. And in my experience, when cases are sealed on the front end and the victim goes to the court to try to get a copy of the disposition that she cannot access.
Got it. Okay. All right. Mr. Davis, I missed one thing. You answered one of the questions about how far you went in school. How far did you go in school?
Oh, I graduated high school,
Where'd you go to high school?
North Clayton High.
North Clayton High?
Yeah, Riverdale.
Okay. So you finished high school. All right. Tell me, you or your lawyer can do this, why this is an offered plea. It sounds like there were some eyewitnesses there who would say he busted in through the screen door. So the burglary part, or what?
As far as the aggravated assault, he said there was an argument, but it did not happen like how it's saying in the police report. And those witnesses are on her side, so they're obviously going to be more in support of the victim.
Her friend and her sister.
Yes, sir.
Okay. Got it. So you have 3 kids or 4 kids?
I have 4 kids.
2 with Ms. Hernandez Alvarez.
Correct.
And then 2 other kids.
Yeah.
And you're 22.
Yes, sir.
Okay, you're amassing quite a collection at a young age, and it sounds like you are already feeling the financial implications of that. It's a lot of responsibility.
Yes, sir.
I hope that you're thoughtful going forward about whether you want to add to the 4 or if 4 is going to be enough for you for a long, long time. You can control that.
Yes, sir.
Yes, you can. But I appreciate that you're trying to provide for the kids. They need a father figure in their life, and you getting locked up doesn't help with that. But it sounds like other than whatever happened in Hapeville a year and a half ago and this, which is particularly old, you've been doing okay.
Yes, sir.
The other 2 kids, are they with the same mom, or is it's a mix of 3 moms?
It's a mix of 3 moms.
Okay. Are you on better terms with the other 2 moms?
Yes.
Okay,
No
good.
problem.
And tell me who, I don't need the name, although we may need to put it in the sentencing sheet. Who is the third party you work when you want to be with the 2 kids you had with Ms. Hernandez? Who is it that you reach out to arrange that?
My mother and my dad.
So your parents, they then reach out to Ms. Hernandez saying, I mean, they're grandparents. And so
Yeah.
they're reaching out saying, could we see are they boys, girls, what?
Boy and girl.
Okay, so we'd like to see our grandkids. And so your parents do that. And then when your parents are seeing them, you obviously can be with your kids.
Yes.
Okay. So it would be your 2 parents who would be the ones, and Ms. Hernandez is saying, that's fine. I don't mind getting a text or a phone call from your mom or your dad.
Yes.
But when it comes to you, Broderick Davis Jr., I don't want to hear from you.
Yes.
You understand that?
I do.
Okay. All right. Are all 4 kids local?
They are.
I mean, Metro Atlanta. There's no one in Virginia. You heard the guy who
Yeah,
pled
they're all
recently.
local. Yeah, they're all local. Yes.
Okay. All right. Do you have questions about anything we've talked about?
No.
Okay. Well, Mr. Davis, I find there's a factual basis for your plea. It sounds like some of what happened, it would be a bunch of witnesses against one witness if there was testimony to a jury. And then maybe what went down specifically between you and Ms. Hernandez once your kid had been taken to that other room might just be he said, she said. But I can understand why you don't want to go to trial. And if the jury credited the testimony of these other witnesses, the jury could find you guilty of both these offenses. So I'll accept your plea, but it's an offered plea. I also find that your plea is knowing and voluntary, meaning you've understood what we've been talking about. Is that a fair statement?
It is.
And no one's forcing you to enter the plea. Ms. Rios, can someone in my office sign the indictment on your behalf?
Yes, Your Honor.
Ms. Beza?
Yes, Your Honor.
And Mr. Davis, can we sign your name to the indictment indicating your guilty plea?
Yes, y'all can.
All right, we'll do that. First offender is something you qualify for. You only have 2 arrests. You have no convictions. It's an opportunity, it's a good opportunity because it means that this is not a conviction. When you leave here today, you don't need to, if you're looking for work, say, well, but I'm also a convicted felon. You don't have to check that box on any applications. And if you get through your sentence successfully with no big hiccups, then it can be expunged, it can be taken off your record. All good for you if you're trying to go back to school, get a job, etc. It carries with it a risk, though, that I need to make sure you understand. You are still young, and even though you are a father of 4, I don't know that you've necessarily grown fully into the shoes of a parent. And if you mess up 6 months from now, 9 months from now, and get angry with one of the mothers of your kids and you hit her or something, you get arrested again, not only will you have those new charges, but I promise you, you're going to be back here. And the prosecution's going to be saying, we gave this guy a chance, first offender, and look, he beat up his girlfriend. If that happens, I will take away your first offender status. It will become a conviction. And I can sentence you up to 40 years. I'm not saying you'll get 40 years. You shoot someone, it'll be 40 years. But if it's just as simple as she got a fat lip or a black eye, it's going to involve some time away from your family and your kids because you will have shown, I'm not there yet. I am not ready to be in a family situation where it's safe for everyone involved. I'm hopeful you're done with all this stuff, but if you're not, I just need you to appreciate the downside of first offender. It gives a judge a whole lot more to work with because I'm going to go along with this recommendation. And so you're going to have 4 years probation. If it were a felony conviction, the most I could ever revoke would be the 4 years. And if you've done a year, then it would only be 3 years. And if you've done 2 years, it'll only be 2 years. But with first offender, if you pick up new charges, then if the state persuades me to take away the first offender status, I get to resentence you. And we're back to these 2 numbers, 1 to 20 for the burglary and 3 to 20 for the aggravated assault. I don't want to share that with you to scare you or anything. I hope if I see you again, it's because we bump into each other on the street, or you're a Uber driver and you drive me somewhere, or you're a doctor and you fix my kid's broken arm. But if I see you in this context, you just need to know it will be a real bumpy ride. You feel like you understand the benefits and the risk of first offender.
Yes, sir.
Understanding that, do you want to be sentenced as a first offender?
Yes.
You pause for a minute. Do you want to talk to your lawyer about it, or you think you got the good and the bad of it?
I think I pretty much got it under.
No questions?
No question. Yeah.
Okay. Then I'll sentence you as a first offender. Your sentence on count 1 is 4 years. Your sentence on count 2 is 4 years. They'll run concurrently with each other, meaning at the same time. They'll be probated. Special condition of probation number 1, no contact with Marlene Hernandez Alvarez. You don't call her, you don't write her, whatever social media things people your age do, don't connect with her through those. And don't use a friend to do that. Hey, Marlene, just Roderick's wondering how you're doing. Don't do that. If she shows the prosecution, look, I keep getting these texts. They're friendly, there's a little heart or it's flowers. If it's from you, that's going to mess up your probation. She needs to go her own way. The only way she knows you exist is because mom or dad are reaching out saying, we'd like to see our grandkids. That's it. You'll need to complete the Family Violence Intervention Program, which is a series of classes that'll help you manage this kind of situation better in the future. 60 hours of community service. You'll need to take care of those in the first 6 months of your probation. And I will set a behavioral incentive date. I'm going to make it 3 years and not 2 years. So January 7th of 2029, if you've done everything you needed to do on probation and there have been no hiccups, they can end it a year early. But with first offender, I'm going to stretch it out that extra year beyond what your lawyer asked for. I think I covered everything. Ms. Beza, anything else from the state?
No, Your Honor.
I didn't ask you this, you may have mentioned it, but Ms. Hernandez Alvarez is aware that this is how the state's recommending the case be resolved.
Yes, Your Honor.
Okay. Ms. Rios, anything else on behalf of Mr. Davis?
I just wanted to put on the record that he has informed me that she keeps reaching out to him and him and his family have concerns because they're like, how do we deal with this situation? Because she keeps calling him.
Great question. Mr. Davis, what you need to do, if that continues to happen, is let Ms. Rios know. And Ms. Rios will then ask the prosecutor to have a conversation with Ms. Hernandez. And Ms. Hernandez may say, you know what? I don't want no contact anymore. I'm okay with phone or whatever. And then we can modify the sentence so that then you could text her back.
Yes, sir.
It's healthier for the kids if you and Ms. Hernandez can communicate. But for whatever reason right now, she is saying no contact. It's not meant to be a trap. If the evidence is she texted you and texted you and texted you, and you finally wrote back saying, knock it off, you're not in trouble. You need to ignore it, but if that's what you did, that's not the kind of thing where the sky falls on you. But if she keeps doing something like that, let Ms. Rios know, because maybe she is rethinking the no contact and wants to be able to communicate with you directly, especially about your kids. Here's a picture of Junior. He took his first step, that kind of thing. A mom might want to share that with the dad. Right now, you can't respond to something like that. But I'm open to changing it if I hear from the state Ms. Hernandez is okay with telephonic contact, or it can be in person, but your mom or dad need to be there at the same time. We can always make it a little more flexible. But for now, it is a very bright line. A text from you to her violates your probation, even if you're responding, saying, stop texting me. Okay? Any questions about that?
No, sir.
Okay. Anything else, Ms. Rios?
Your Honor.
Your address, is it in Fulton County?
No.
What county?
Clayton County.
Clayton County? Okay. When we're done here, you're going to meet with Ms. Simpson, who's going to give you reporting instructions for probation. You'll report to Clayton's probation office because you live in Clayton County. And that's where you'll be supervised. I'm not going to seal anything right now. If we end up modifying the sentence because Ms. Hernandez wants to have contact with Mr. Davis, then you should renew the request to seal.
Thank you.
Okay. All right. That's it. Good luck.
All right. Yes, sir.
No more kids.
Joe.
It's not on me.
Are you ready on Nash? That's my last. You're not. No, so you just right here. Oh, yeah. It's just.
No, no, I'm still.
Okay. Oh.
Is there a
You guys want to do
student
meetings?
attack me?
So we can do Ms. Toussaint, but I think we had an announcement first.
Yeah, we may have an announcement on Nash, Your Honor.
Willie Nash. Mr. Nash?
It's just a final year.
Oh, okay. Is he here?
He's the one that's on Zoom.
Oh, he's our truck driver.
Yes, I just texted him because I think he might have fallen off when I called.
He's on. I see him on here. I had muted him, but he's here. So why don't you see when he can be on the side of the road?
I was telling him it's longer.
Okay. All right, so we'll do that. We're gonna do Ms. Toussaint. And then the gentleman in the back, I'm not remembering your name.
Mr. Gresham.
Mr. Gresham, right. That was on plea and arraignment, and he's the gentleman where the victim showed up as well. What are we doing with Mr. Gresham?
We're just waiting for when Mr. Miller has a chance to speak with the victim.
Got it. Who is still here? A patient man. Okay. And then we have to still talk with Ms. Lewis. All right. Well, I would say let's do the Toussaint plea, but if that's with Mr. Miller, then maybe Ms. Beza could talk with the Gresham victim?
Yes.
That would be great.
And Mr. Nash says he's pulled over.
Oh, he's pulled over. So let's do that first. Then we'll do Ms. Toussaint. And look at that, hands off the wheel. Okay. All right, if you'll come on up to the podium, Ms. Wood. Let's get on the record with position 5 on our final plea calendar. It's 25 SC 004983, State versus Nash. Mr. Nash is appearing virtually from his big rig. Where are you right now, Mr. Nash? What state?
Currently in Tennessee.
Tennessee? Where in Tennessee? That's a long state. Closer to Nashville or?
The bottom
Yes.
west portion, Memphis.
Okay. And where are you headed? What's your destination?
I'll be in Georgia soon.
Okay. Are you hauling something now or is this deadhead miles?
I am hauling something.
What's that?
I got some Tyson meats.
Tyson meats. Well, I got to get you back on the road. No one wants that to go bad. I hope you got a refrigeration unit on there. Mr. Nash, we are going to have your final plea discussion right now. Ms. Wood, do you feel like you've got all the discovery that you'd expect in a case like this?
Yes, Judge.
Okay. What is it that was damaged allegedly?
Ooh, I don't remember.
Okay, don't worry. I'll look it up while we're talking. So you've got discovery. Mr. Miller, is this a case you're handling right now or Ms. Beza?
Me.
Ms. Beza, what is the state's offer? If Mr. Nash were to go forward with a plea today, what would the state be recommending?
Count 1 reduced from criminal damage to misdemeanor criminal trespass, and count 2 remaining the same as reckless conduct with a sentence of 12 months probation, complete an anger management course, no weapons, 60 hours of community service, and no contact with the listed victim, which at the time was his boyfriend.
All right, so the 12 months probation, and during the course of those 12 months, take an anger management course, 60 hours of community service, and no contact with Evan Austin.
That is correct, Your Honor.
Got it. Okay. Mr. Nash, do you understand what the state is recommending at this time? It's a reduction of the felony count to a misdemeanor and then a plea to 2 misdemeanors. The sentence would be 12 months probation with the 3 conditions. Take the course, do the community service, and no contact with Mr. Austin. You understand that?
Yeah, I believe I do. Yes, sir.
Okay. Any questions about what the state's recommendation is?
Currently, no.
Okay. It sounds like, from what Ms. Wood told me, you are not interested in resolving the case by way of a plea to those conditions.
Not these conditions, no, sir.
Okay. Is there a particular condition that's the issue?
It's more or less the probation, as well as the 2 counts, criminal trespass. I mean, I was clearly staying there. That was my home, so
Okay.
it's not making sense to me.
Okay, got it. Well, one of the counts is reckless conduct, which has nothing to do with the location. It has to do with the behavior at the time. And I'm not attributing any behavior to you, but the allegation is not trespass. It was that it was reckless to discharge a firearm in the household. So it has nothing to do with trespass. And just play legal eagle here for you. This reduction of count 1 as it's currently crafted is an allegation that you did damage in excess of a certain dollar amount to property of Mr. Austin. The reduced version of that is actually called criminal trespass. It doesn't mean that you're in the wrong place, but if I was in your house and I brought with me a prized baseball bat of my own that was worth $200, and you broke that baseball bat, that crime would be criminal trespass. You're in your house, you are where you have a right to be, but you damaged my property, but the value of it was less than $500. And so that's a misdemeanor criminal trespass. It sounds like people hear trespass and they think I'm where I'm not supposed to be. And that is one meaning of criminal trespass. If you came into my house and broke the baseball bat, you'd be trespassing at my house. If you did it in your house, you have trespassed upon my baseball bat by breaking it. That's the misdemeanor. So, but I'm not trying to persuade you one way or the other. I just don't want you to get hung up on. They're saying I was where I shouldn't be. That's not what they're saying. They're saying they're reducing the value of the property that was damaged. That's count 1. And count 2 was never criminal trespass. It was always reckless conduct which it is if in fact a firearm was discharged in your house or anyone else's house. But you are saying no thank you to the state's offer, which means that we moved your case to the March trial calendar. You will need to be here in court, not driving your truck in Tennessee or Georgia or anywhere else, on March 12th for the call of the trial calendar.
And Your Honor,
Yes, ma'am.
if he were to take a plea today, then the state can null pros count one. For purposes of a resolution, as a probated offer is just 12 months.
Got it. So the count one, that's not a hang up for the state.
No, it's not.
Okay. So this is a real-time change, Mr. Nash, and you may want to talk to Ms. Wood about it, but the state is saying, look, our focus is let's get the anger management, the no contact with Mr. Austin. So they're willing to just dismiss count one, and all you're doing is pleading to reckless conduct, count two, the discharge of the firearm on, what was the date? Oh, it was New Year's Day, 2024. That's the allegation. Does that change anything in your mind, or you still want to be here on March 12th for the trial calendar?
I'll probably go ahead and go forward with the trial calendar.
Okay. Well, you get something in the mail, but I'm telling you right now, so this is the notice you're getting. We'll see you on March 12th. You should know two things. One, the state's offer is not anything that you can or I can require them to extend beyond today. So if you roll in here on March 12th saying, I thought about it more and I'll do that reckless conduct thing, you may be met with a look of, I don't know what you're talking about. That was an offer for January 6th and not March 12th. So they may be back to, hey, we got ready for trial and we're going to go forward and we're going to demonstrate that the property in the household that was damaged by the discharge of the firearm was worth more than $500, and there's your felony, and you move forward. So there's no guarantee that it will be the same offer. Number two, the other important thing is that after today, if the sentence that I impose is more than what Ms. Wood asked for on your behalf, you don't get to withdraw it. So today, if I heard all the facts and circumstances and I said, you know what? I think that there ought to be a fine. Mr. Nash should have a $1,000 fine. That is not what Ms. Wood asked for. You could say, nope, I'm withdrawing my plea. If on March 12th or any day after today, you decide you want to work it out with a plea, we can still do that. And it may well be that the state still offers you a misdemeanor, but you do not get to withdraw your plea if the sentence that I impose is different from what your lawyer asked for. You understand that?
I think so.
Well, I need you to say you're pretty darn sure you understand it, as opposed to maybe you understand it.
Well, could you repeat it?
Sure. Two things change after today. One, no guarantee of what the state's offer will be. It may no longer be one misdemeanor. It may not be 12 months probation. Could be worse. You don't get to enforce today's offer after today. Number two, if you do enter a plea tomorrow, the week after, or the day I'm going to see you, March 12th, I'm happy to accept that plea. You do not get to withdraw the plea if the sentence I give you is more significant than what Ms. Wood asked for. Today, she would ask for X, Y, and Z, whatever you guys have been talking about. And if I went above that, you could say, nope, I was willing to do exactly what Ms. Wood said. And Judge, you gave me something extra. No, thank you. No harm, no foul. We just move you to the trial calendar. After today, you can still plead. You do not get to withdraw that plea if you are unhappy with the sentence you get.
Okay.
You got it?
I think, yes.
Okay. Understanding all that, what I'm hearing you say, Mr. Nash, is that you will be here on March 12th for the trial calendar. Is that correct?
That's correct.
Okay. Ms. Wood, do you need anything else on behalf of Mr. Nash?
No, Judge.
You're good to go? All right. Ms. Besa, anything else from the state?
Yeah, just for the record that this offer does expire today.
Okay.
And so that is all from the state.
Got it. Offer is off the table when Mr. Nash gets off the Zoom call. Mr. Nash, I will see you in person. You need to look for a real big parking place if you're driving the truck down here on March 12th, okay?
Will do. Thank you.
Bye-bye.
Thanks, Judge.
And that concludes my business. May I be excused?
Yes, ma'am. Thanks for your help today. We ready with Ms. Toussaint?
Did you speak to the committee?
Your Honor, regarding, yes, I did. Thank you. I have an announcement regarding position 3, Mr. Donald Gresham.
Yes, from our plane arraignment calendar.
Yes, Your Honor. The alleged victim in this case, Mr. Antonio Strong, did appear in court today. Mr. Strong informed the state that he misidentified Mr. Gresham, and that is not the correct defendant. He did provide the correct identifying information to law enforcement. I did take down Mr. Strong's information. He and I will work with law enforcement to identify the correct person. With that being said, Your Honor, the state moves to null process case regarding Mr. Gresham.
Got it. So two things. First, Mr. Strong, I appreciate you doing what you just did. You didn't have to do that. It's the right thing to do. We have the wrong person accused of a crime here, and you are short-circuiting the process in a very admirable way. So thank you for doing that. Mr. Gresham, I'm sorry on behalf of the criminal justice system that you got tagged with this situation that you had nothing to do with. The state has moved to dismiss. You heard a different term, but that's the impact of what Mr. Miller is asking for. And so I'll make sure we take care of the paperwork today, but your case is dismissed. You do not need to come back to court in connection with this. If you need any paperwork documenting the dismissal, reach out to Ms. Wood and she'll get that to you, okay? All right.
And Your Honor, in regards to Mr. Gresham's GCIC.
So, hey, you know what? You were doing what you thought you were doing. And I appreciate you guys shaking hands. This is sort of a justice moment here. It's a good way to start the year.
And Your Honor, regarding Mr. Gresham's GCIC criminal history, I just want to make sure that the arrest is either sealed or taken off of his GCIC.
Great. Ms. Wood will take the lead on that one.
Okay, thank you.
Okay. Thank you, Mr. Miller, for handling it that way. All right, Ms. Toussaint. We keep saying we're ready and then you have to freeze up. Come on up here. All right. Let's open the record on this case. It's 25 SC 004763, State versus Toussaint. Ms. Toussaint is up at the podium. Counsel, will you get your name on the record for our court reporter?
Mike Jacobs.
We've got Mr. Jacobs here for Ms. Toussaint and Mr. Miller for the state. Ms. Toussaint, in just a moment, Mr. Miller is going to put you under oath and then ask you the same kind of questions you've heard other people get asked. You'll need to answer truthfully and completely. And if at any point you need to speak with Mr. Jacobs or you've got questions for me, you'll let me know.
Yes, sir.
Great. Then let's get started.
Thank you, Your Honor. Would you please raise your right hand? You swear and affirm that the testimony you provide regarding this matter will be the truth, the whole truth, and nothing but the truth.
Yes.
Please state your true and correct legal name.
John A. Toussaint.
And can you spell your first and last name, please?
First name ZHANAE. Last name TOUSSAINT.
You can put your hand down.
Ms. Toussaint, are you at the time taking or under the influence of any alcohol, drugs, or medicine?
No, I'm not.
Is there a medication that you normally take that you have not been given today?
No.
Ms. Toussaint, how old are you and how far did you go in school?
25, and I completed my high school diploma.
So you're able to read, write, and understand the English language. Is that correct?
Yes, sir.
Ms. Toussaint, you understand that you are charged with the following offenses in indictment number 25 SC 004763, 1 count of aggravated assault, 1 count of criminal damage to property in the first degree, and 2 counts of possession of a firearm during the commission of a felony. Do you understand?
Yes, sir.
You understand that you have a right to either plead guilty or not guilty to these charges, and if you plead not guilty or remain silent, you may receive a jury trial.
Yes.
Have you gone over the waiver of rights form with your attorney?
Yes.
Do you have any questions regarding the conditions in this form?
No, sir.
And is this in fact your initials on this form?
Yes, sir.
And does your signature on the second to the last page of this form indicate that you understand all the terms that are listed and the rights that it went over regarding this form?
Yes, sir.
Have you had enough time to speak with your lawyer about all the facts and circumstances known to you regarding charges in this indictment, including any potential defenses?
Yes.
Do you need more time to discuss this case with your attorney?
No, I don't.
Are you satisfied with his services?
Yes.
Counsel, are you satisfied that your client has a full understanding of these proceedings?
Yes.
Counsel, do you waive any and all defects in the indictment, including any with respect to your client's name?
I do.
Mr. Hussein, have you been arrested on these charges?
Yes.
The state is unaware of any outstanding warrants related to these charges. Do you or your attorney know of any outstanding warrants related to these charges?
No.
No.
Has your attorney advised you of the minimum and maximum sentence for each charge you are pleading guilty to today?
Yes.
For example, the charge of aggravated assault carries a sentencing range of 1 to 20 years. Count 2, criminal damage to property in the second degree, carries a sentencing range of 1 to 10 years. And the 2 counts of possession of a firearm during the commission of a felony is a 5-year sentence that runs consecutive to the other counts. Do you understand?
Yes.
Do you understand that this is a negotiated plea, which means the state will recommend to the court the following sentence? For count 1, aggravated assault, 5 years to serve 2 years, suspended with the balance probated. Count 2, criminal damage to property in second degree, 5 years to serve 2 years, suspended with the balance probated to run concurrent with count 1. And counts 3 and 4, possession of a firearm during the commission of a felony, 5 years probated, but consecutive to counts 1 and 2. However, the court does not have to accept this recommendation and can sentence you to the maximum on each charge and can run those sentences consecutive or concurrent. Do you understand?
Yes.
Do you understand that if you do not accept the court sentence, you may withdraw your plea?
Yes.
You understand that if you are placed on probation at any time, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence.
Yes.
You understand that this is a guilty plea which may be permanently recorded on your criminal history.
Yes.
Do you understand that if you are currently on probation or parole, your probation or parole may be revoked based on you entering a guilty plea today?
Yes.
You understand that if you are not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at trial would. And that is true regardless of any advice by your attorney or anyone else.
Yes.
You understand that neither the court, your attorney, nor the district attorney's office has anything to do with parole, and no one can guarantee parole no matter what anyone has told you.
Yes, sir.
You understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial. For example, your guilty plea may affect your right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment. Do you understand?
Yes.
You understand that by pleading guilty to a felony, you cannot use, receive, possess, or transport, or own a firearm, and that if you do, you could be charged with another felony offense.
Yes.
You understand that that is true even if you are pleading under first offender.
Yes.
Now, are you asking to be treated as a first offender under the provisions of the First Offender Act?
Yes.
Have you ever pled guilty or nolo contendere to or ever been convicted of a felony in the state of Georgia or any other jurisdiction?
No.
Have you ever been sentenced for any crime, felony, or misdemeanor under the First Offender Act?
No, sir.
Has your lawyer explained the First Offender Act to you?
Yes, sir.
You understand that if you violate the terms of your first offender sentence or commit a new offense while on first offender probation, your first offender status could be revoked and you could be adjudicated guilty and you could be resentenced to up to the maximum sentence for each charge in this indictment.
Yes, I understand.
You understand that the federal government considers a first offender plea a conviction for the purpose of deportation, and it could still affect your ability to remain.
Yes, sir.
You understand that you waive any and all defenses, including any mental health defenses, by entering a guilty plea.
Yes, sir.
You understand that by pleading guilty, you are giving up the following rights. And I'm going to say them one at a time to make sure you understand. You are giving up the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see, hear, and confront witnesses called to testify against you and to question them, The right to assistance of counsel hired by you or court-appointed counsel if you cannot afford an attorney at the trial of your case. The right to the presumption of innocence, which means that the state must prove you are guilty for each charge in the indictment beyond a reasonable doubt. The right to testify on your own behalf or remain silent, and the jury would be told that they cannot use that choice against you. The right to present evidence on your own and to call your own witnesses if you choose, and the right to appeal if convicted of these charges after trial. Do you understand that you are giving up those following rights by entering a plea today?
Yes, sir.
Counsel, are you satisfied that your client understands these rights and they'll be waiving by pleading guilty to these charges?
Yes.
Ms. Toussaint, has anyone forced, threatened, or promised you anything to get you to enter a guilty plea today?
No, sir.
Is it your decision to waive these rights that we just talked about and enter a guilty plea because you are in fact guilty?
Yes.
How do you plead to the charges in indictment number 25 SC 004736, and those charges are aggravated assault, count 2, criminal damage to property in the first degree, and counts 3 and 4, possession of a firearm during the commission of a felony?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
You understand that you do not have a right to appeal directly from your guilty plea, but if you believe there is some error in your guilty plea, you can apply for the appropriate appellate court to request a discretionary appeal.
Yes.
You understand that the discretionary appeal procedure, which is outlined in OCGA section 5-6-35, must be completed within 30 days of today.
Yes.
You understand that you have only 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea.
Yes, sir.
Thank you, Mr. Singh. Your Honor, had this case gone to trial, the state would have been able to prove beyond a reasonable doubt that on March 24th of 2025, officers responded to 5019 Cottage Grove Place in Atlanta, Georgia, also located in Fulton County, regarding a dispute. Upon arrival, they spoke with the alleged victim, Ms. Sheila Chapman, who stated that she was shot at by the girlfriend of her child's father, and she identified that suspect as the defendant, Ms. Toussaint. Ms. Chapman indicated that she was shot at while she was in her vehicle. She stated that she was sent to the location to meet with the father of her child, who was not on the scene, to confront him about a previous incident that occurred. And during the conversation, the child's father left the location, and that's when the altercation with Ms. Toussaint had proceeded. She stated that she did not say anything to physically assault Ms. Toussaint. She also indicated that she attempted to leave the location in her vehicle, and at that point, she stated that Ms. Toussaint fired 2 shots from a handgun toward her vehicle. Officers observed 1 entry hole to the back window of Ms. Chapman's window, and they also saw a flat tire on Ms. Chapman's vehicle as well. They also located 2 9mm shell casings from the scene. While conducting an investigation, Ms. Toussaint arrived back at the location, and when officers approached her, they saw what appeared to have been a handgun contained in her pocket. They did do a pat down, and they retrieved a 9mm Glock 43 9mm pistol. She was read her Miranda rights, and she agreed to speak with the officers. And at that time, she admitted that she did fire 2 shots at Ms. Chapman's vehicle, one hitting her tire and the other hitting the rear window of Ms. Chapman's vehicle. She stated that she shot at the vehicle out of self-defense because she had been harassed multiple times in the past by Ms. Chapman. However, but when asked if Ms. Chapman had physically assaulted her at that time before she fired the handgun, she stated no. Your Honor, the state was provided some additional information by defense counsel today that somewhat contradicts the report. It also states that in the transcript that this defendant and our victim had been kind of engaged in some type of ongoing dispute in which the defendant may have been threatened by our victim multiple times prior to the incident taking place. Your Honor, due to her lack of criminal history and due to the background regarding this incident, the state is recommending a total sentence of 10 years to serve, 2 years suspended with the balance probated. We also asked for the following conditions. Of course, no contact with Ms. Sheila Chapman. We also asked that the defendant submit to an anger management course, that she forfeit all firearms and have no firearms, weapons, or replicas. We also asked for a 4th Amendment waiver And when it comes to the damage that Ms. Chapman's vehicle sustained, we ask that a restitution matter be set later, Your Honor, once we provide that documentation to defense counsel.
All right. So the way you understand it, the connection between Ms. Chapman and Ms. Toussaint is that Ms. Chapman had a child with the person that in March of last year, Ms. Toussaint was seeing.
Yes, Your Honor.
Okay. All right.
Nothing further from the state, Your Honor.
Thank you. Ms. Jackson, criminal history information on Ms. Toussaint, please.
There are 3 cycles. The last arrest was November the 5th, 2025 in Turners County for 5 counts of obtain / procure, give inmate prohibited items without authorization. There was no disposition for that arrest. Also, she appears to have an open case out of Douglas County for 2 counts of burglary in the 2nd degree. Nothing in addition.
The first case you mentioned, is that a Georgia case?
It said Turner County, Georgia.
Okay, Turner County.
That's in South Georgia, way south.
Okay, I'm gonna look it up, never heard of it. Huh. Okay. Mr. Jacobs, share with me what you want about the case, but I also would like to hear a little bit about first offender, and gosh, she's got 2 open cases.
Yeah, I can address the Douglas County case because I'm retained on that one. The Turner County case, I don't know anything about.
It's
As
pretty
far as
fresh
the facts,
too.
It's pretty fresh.
Yeah.
I don't know. I'm not retained on that. I'm not sure who attorney down as Turner County is on that one.
Okay.
The Douglas County case, we are going to trial on that. It's not set for trial yet. What happened in that case was a friend of hers worked security at an Amazon warehouse. The security guard let Ms. Toussaint into the Amazon thing, gave her permission to come through with employee entrance. They took something out of that, so they did commit a theft. They charged her with burglary, but we have the security guards saying that I let her in, she did not burglarize, I gave her permission. So we're going to trial on a burglary charge on that.
It's more of a shoplifting or theft.
It's more of a
It's not really a shop, but it's a theft situation as opposed to burglary.
Exactly.
Okay.
Yeah.
What was taken?
I don't know the exact items. There were several items taken.
Okay.
So yeah, so we're going to trial on that, unless they offer us to plead to a theft by shoplifting or something.
Okay.
But it wasn't a burglary.
Okay. And when-ish did that happen?
When did it happen? I'm drawing a blank on the timeline of that, the Douglas County case.
March of the year before.
Yeah, it was into 2024. She says March. That's probably right.
Okay.
Yeah.
So a year before this situation with Ms. Chapman.
Exactly. Yeah.
All right. And then you don't know much about the Turner County situation?
I do not know about Turner County.
Okay. Ms. Toussaint, I'm gonna hear more from your lawyer, but since we're on that topic, I don't want you to say anything other than yes, if yes is the right yes or no. I'm not trying to get you to admit to anything. I'm just trying to figure out what the heck the charge is down in Turner County. It sounds like it's you went to visit an inmate and provided that inmate something that the inmate shouldn't have. Is that the nature of the allegation? Or what is it you understand you're in trouble for in Turner County?
So to be honest, I drove a friend down there to dump something in the jail dumpster, but because my vehicle was on camera, they have my tag number, so they're charging me.
Sure, it was your car, but so someone in your car was trying to leave something that in theory would get to, your friend knew someone who was in prison or jail in Turner County.
Yes, sir.
Got it. And you drove all the way from Atlanta down to Turner County. All right. Good friend. Back to you, Mr. Jacobs.
Yeah, briefly before I go into the facts of the case, she does have a good job. She's a general manager at U-Haul. Her boss is here in the courtroom. Her boss came to support her today. Her boss is aware of everything involved in the case, and she still has her job. There's no with that. As far as the facts, as the state alluded, there's a bad history between these two. They share a child's father, or they each have a child with the father. Miss Chapman has been terrorizing her for a long time now. She shows up at her house with weapons. She threatens her repeatedly. She goes on her social media. And while Miss Chapman was serving a prison sentence for trafficking, she was communicating and terrorizing her through
Trafficking drugs, human trafficking.
Human trafficking. And then when she got out, she was terrorizing Zanae, coming to her house with weapons, threatening to kill her, to the point that Miss Toussaint was granted a TPO in Clayton Superior Court against her, and that is still active right now. The only time she's ever owned a gun in her life was pretty soon before this incident took place. She bought a gun just for self-protection, specifically against Miss Chapman. On this day, Miss Chapman pulled up, started threatening her, got out of her car, was coming towards her, and she shot at it. She had on the body cam video, I had the entire thing transcribed and sent to the state last night. She videotaped the entire thing on her cell phone, except for the
She meaning Ms. Toussaint.
Toussaint, yeah.
She's filming, look, here's this lady at my house, not supposed to be here. She's getting out of her car. She's coming towards me.
Exactly. And the police looked at that video. The shooting's not on video because she put her phone down before she shot.
Yeah.
And so I sent the transcript to the state last night. I think that's what led the state to come off from 10 years with 2 to serve in prison to today, 10 years to serve 2, but suspending that, assuming she complies with everything on probation. And that's where we are today. Ms. Toussaint has no interest in ever contacting Ms. Chapman. She's scared of her. I've told her that if Ms. Chapman ever comes to her house, to call the police. If she feels that she's threatened and she comes to her house, she knows she's not going to ever reach out to Ms. Chapman after this. So we're asking Your Honor I know it is a dangerous case anytime you start firing a gun at somebody. It's a bad case. And normally a case like this, when you're shooting at somebody, would require prison. But we're asking Your Honor to consider the suspended sentence, given the fact that she has no prior convictions and she does have a good job with somebody who's here supporting her, who's her boss. And we're asking Your Honor to give her a chance to comply with the terms of probation and show that whatever she had going on in her life is behind her and she's going to work, go home at night and not get in trouble anymore.
Okay. You've had a lot going on the last year or so. Ms. Toussaint, a few questions from me. What's the last name of the gentleman who has a kid with you and Miss Chapman?
Cole?
Mr. Cole?
Yes, sir.
Okay. So you have a child with Mr. Cole?
Yes, sir.
Okay. Do you have other kids or that's your one kid?
One kid.
Okay. Boy or girl?
A girl.
Okay. And does she stay with you?
Yes.
Is Mr. Cole active in her life?
He's currently incarcerated.
Okay. If Mr. Cole were here right now, would he say, these days I'm talking with Miss Toussaint, or these days I'm talking with Chapman, or I got another young lady in my life?
We still communicate, but as far as a relationship, I've been in a lot of stuff behind him, so I'm trying to move on and do better.
Okay. So you aren't looking to maintain, other than you are co-parenting, a relationship with him?
Correct.
Okay. How much longer is he supposed to be in jail?
He just got transported to federal custody, so it might be a while.
What's he doing in federal custody?
Transportation to engage in criminal sexual activity of a minor.
He's going to be in federal prison for a long time. Okay. And then Miss Chapman, someone was saying you were saying she's in jail for trafficking. She is now, or she had been?
When I met Cole, she was currently serving a 6-year sentence for sex trafficking. When me and him would post on social media, she would DM me from a contraband phone she had and just threaten me of what she would do once she got out.
And then she got out.
And 2 months after her release, she arrived at my home with a knife. I relocated. I called the police. I filed a report. She found the new address. I did it. I know I made a poor decision, but it was to protect me and my family. I felt that was the only choice I had, to let her know to like just leave me alone. I'm currently a general manager and I'm just trying to do better with my life. And I'm also a single mom.
Okay. Where you stay, is it just you and your daughter, or do you have?
So I was staying with Cole, but
Right.
from everything I've been going through, I'm back with my mom until I can get my own self together for me
Okay.
and my daughter.
And what county is that in?
Clayton.
Okay. All right.
And her mom is in the courtroom this morning as well.
Hi, Mom. What days of the week do you work at U-Haul?
Monday through Saturday.
6 days a week?
Yes, sir.
How many hours?
Uh,
I mean, like a
as a
typical.
general manager, I'm doing maybe 8 to 10, full shift. I'm full time.
Okay.
And I love what I do.
Good. Where's the U-Haul place?
In Atlanta, Georgia, DeKalb County,
How long have you had that job?
since July. So within 5 months, I've received 2 promotions.
Okay. Do you have, the gun that you had, where'd you get it?
I bought it
Okay, but you bought it like at a gun store or
at a
from?
gun show, but it was registered to me. I bought
Okay.
it at a gun show.
And when's the last time you heard anything from Miss Chapman after this situation?
So I filed the TPO when I was released. In June, when the TPO was in place, she was still coming on my social media, engaging with my posts. And I knew it was her because she came from a profile with the same profile picture that she had previously sent threats on. But that was back in June. So since then, nothing now.
Okay, so she's left you alone as far as you can tell since June?
So far, yes.
Okay, all right. I need to, where is the U-Haul boss? Hey, U-Haul boss, how are you? Thank you for wearing corporate gear. I don't want to interfere with Ms. Toussaint's job. It sounds like she is doing good work and you'd like to keep her around. Tell me how it flows, either because you're in charge and you make the decision, or U-Haul corporate policy if someone has a felony conviction. Are you able to hire people with felony convictions?
Yeah.
Okay,
Actually, we do hire people with felonies. The
Great.
CEO of our company believes that everybody has a past and,
and a future.
yeah.
Okay,
And so it's not gonna affect her at all.
okay,
What we really care about is she has a great reputation, she has great customer service, and she works really hard.
sounds like it. I mean, it sounds like 60 hours a week. I'd hire her for my U-Haul too. Dang.
Well, that's just until she gets hired up. We had to pretty much fire an entire store, so now she's hiring her team.
Okay,
So she's working a lot of extra hours until she gets staffed up.
good. All right. Thank you for being here. All right, well, Ms. Toussaint, I find there is a factual basis for your plea. You've admitted to what happened, but you and Mr. Jacobs have provided some context. What happened was was she in the car when you shot through the back window, or she had not gotten back in the car yet?
No, she hadn't gotten back in the car.
Okay, so you shot up her car with her not in the car. Did you know if she had any kids in the car?
No, it was no kids in the car
How did you know that?
because her window was down and
Okay.
her driver's side door was open.
Okay, so you could see into the car, and your understanding is there was no one in the car.
No one was in the car.
Okay. Still a dangerous thing that happened. Could have been someone lying in the back seat, or a bullet ricochets and you were not aiming at her, but it hit some metal and it hits her thigh and she bleeds out right there. And then we're not talking about your job at U-Haul. We're talking about life or 30 years. And you've got a little one who would get to know mommy through plexiglass. It was that close to it being that kind of thing. That's what happens when you start pulling the trigger. I'm not criticizing you protecting yourself. That's not my point at all. It takes it to a whole nother level when people pull triggers. So fortunately, it was just a Kia Forte that took it. But that got pretty messy. I find there is a factual basis for your plea to the things you're charged with, and that your plea is knowing and voluntary. You've been very well counseled in terms of the representation that you have retained, and I get the sense that you followed all the things we talked about. Do you have any questions about anything we've discussed?
No, sir.
Okay. I also find that your plea is voluntary, meaning that no one is forcing you to do it. Mr. Jacobs, can someone in my office sign the indictment on your behalf?
Yes.
Mr. Miller?
Yes, Your Honor.
And Ms. Toussaint, is it all right if someone in my office electronically signs your name indicating your plea?
Yes, sir.
All right, we're going to do that. I'm going to sentence you a little differently. The suspended part, I understand that it's a proxy for the 2 years you were going to serve if the facts had been other than what Mr. Jacobs was able to show the state, the power of recording things. We all should have body cams until you're in a private space. But what I'm going to do is sentence you to 8 years probation, which is effectively what this was. It was 10 years to serve 2, but the 2 years were suspended. I'm going to sentence you to 8 years probation. It's a long time, but it's appropriate given the seriousness of the situation. And frankly, the fact that you've got 2 other potential felony cases bouncing around, it's a rough year for you. But just like your boss said, people have a past and they have a future. And you're right now, and future is looking like you've tightened some bolts inside and are making better decisions. While you are on this probation, no contact with Ms. Chapman. I know you don't want that. So that's an easy one. As you may have heard me say to someone who preceded you up here, that's not meant to be a trap. If she is contacting you, just record that, make copies, give it to Mr. Jacobs so he can get it to the prosecutor and they can say, you need to knock it off, Chapman, because we're not going to go after Ms. Toussaint because you bait her and she finally writes back and says, leave me alone. You are not going to get in trouble for that, but just don't say, leave me alone. Get it to Mr. Jacobs. And ultimately, we may need to reinforce the TPO. But that applies. And if she's contacting you, she's violating it. And you need to bring that to your lawyer's attention so he can bring it to the state's attention, because that's called aggravated stalking when someone violates a TPO. You will need to complete an anger management course. You will forfeit the Glock that you bought at the gun show, but that's no huge loss. You may lose a little bit of money, but you can't have a gun while you're on probation anyway. And in fact, you're not going to have a gun anymore. And there'll be a Fourth Amendment waiver while you are on probation, which just means if probation has some reason to think, this is a little weird, we want to search your bag or do this or that, they don't need a warrant to do that while you're on probation. I'm not sentencing you as a first offender. That's why I asked your supervisor if this outcome would impact your future with U-Haul, because that sounds promising. I'm not comfortable saying, hey, this was a first time thing, given all this other stuff you've got going on. And I appreciate that your good lawyer is going to shake those folks in Douglas saying it's not a burglary, but it was still a theft. And we got this thing down in Turner County. And so I don't think it is truly reflective of what was going on to say she'd never been in trouble before. Those other cases may all go away. That would be a good outcome for you. But I'm not comfortable given the gravity of what this was about and the other things that I've learned about that were going on with you as recently as 2 months ago. And then sounds like the Douglas County thing was about a year before you shot up Ms. Chapman's car. So it is probation. It's not first offender probation. It's all the conditions that your lawyer negotiated. Mr. Miller, anything else on behalf of the state?
I'd just like to add also, Jan, that the state did reach out to the victim multiple times to provide her with the amended offer.
Okay. All right. Mr. Jacobs, anything else on behalf of Ms. Toussaint?
No, Your Honor.
Ms. Toussaint, do you have any questions about how this is going to work?
No, sir.
You've never been on probation before. You're going to be on probation now. It will become less and less intrusive the better you do in the process. So if you are checking in whenever your officer needs you to check in, they give you more and more degrees of freedom. And so it may become unsupervised after a couple of years where, yes, there's this probation out there, but it's actually not anything that's limiting the things you want to do in your life. Because you live in Clayton County right now, that's where you'll be supervised. If you move because you get your own place or you and your mom move, that's fine. You just need to let probation know that you've got a new address because that may shift the supervision to a different county if you move to a different county. Ms. Simpson is going to give you all the reporting details. Do not miss your reporting date with probation. That's how things get started, and you get into their system. If you don't show up for that, they just reach out to me and say, we need a warrant for Ms. Toussaint. And it's just, that would be the wrong way to start probation. Okay?
Yes, sir.
Any questions?
No.
All right. Well, you should thank your mother and you should thank your supervisor. Having them here is a big impact because it shows me there are folks who know you well who are here for you and believe in you. And that's good to have.
Thank you.
Okay? What's your kid's name?
Honesty.
Honesty. That's a burdening name. All right. Good luck with things.
Thank you.
Thank you very much, John.
Thank you, Mr. Jacobs. And thank you, Mr. Miller.
Thank you, Your Honor. Thank you.
So it's kind of lunchtime. I know we've got a few other things. I want to make sure Ms. Rivers and others get a little bit of a break. I think we have a plea with McCrary. You can go talk. I'll let you know what we're going to do. We got a plea with McCrary, maybe a plea with, we still have our revocations too. So yeah, we should take a lunch break. But maybe a plea with Ms. Brown, if you can be persuasive. And then we still need to talk with Ms. Lewis. But if we took like a half hour, does that work?
Your Honor, could I have 2 minutes to speak with Ms. Rios regarding Ms. Lewis? 'Cause
Sure.
we may have an announcement.
Sure.
For that one.
Sure.
Thank you.
Yep. I'm happy to press on, but I also, it's a new year and I want to be respectful of people's needs for breaks. And we've been going since 9. And I'm happy to take care of these other things. I'm not going anywhere. I'll just come back out in 30 minutes and we'll do other stuff. People can get a break that way.
Okay.
So the church, you can get it back in. Yeah, you can go back to her home. If her ticket comes there, so this have to get her together.
Okay. And
I think it's a little bit,
You didn't bring them up?
but.
It's an add-on calendar.
Okay. Man, she can do it.
No, I would listen. Thank you.
I'm not gonna fight you.
I'm gonna make that announcement.
Your Honor, the state has an announcement regarding Ms. Lewis.
Okay. Should we bring Ms. Lewis out so she can hear it?
If you can, yes.
We could.
Okay.
That's fine.
We just have her right at the door.
Okay.
That's not, she's very sweet lady.
Ms. Wood, I was suggesting we take a 30-minute break for lunch just because we got folks who've been going since 9. We need to also figure out where Mr. McCrary is. But that doesn't mean he's not downstairs. You just may not have known you need to bring him up.
His car would have been in the box.
Pardon me? Oh, I don't know how that works down there. We'll talk with Ms. Nelson. He's a high priority for Colonel Edwards, although he had to be located so that it was more difficult for him to continue to, we can talk about it, not in here. He's someone that Ricky Pierce could be a hero about.
It's Ricky Pierce.
Not ours.
Oh, is that the private murder, that he used to be mine.
Oh, that's right.
Mm-hmm. Fired him. Mm-hmm. Respectfully though.
Sure, respectful. Hey, is this Ms. Lewis? Hi, Ms. Lewis, just stay right there.
You can sit if you want.
Or you can take a seat. Ms. Lewis, I'm Judge McBurney.
Yes.
And the prosecutor, Mr. Miller, had an announcement on your case. I wanted to make sure you were out here to hear it so we can see what we're going to do with your case. What is that announcement, Mr. Miller?
Yes, Your Honor. This incident stems from a 2024 incident date in which Ms. Lewis is alleged to have taken maybe $40 worth of baby clothes. Your Honor, although probable cause existed at the time for her arrest, the state just believes that in the interest of justice that this case should be null pros.
Okay. So Ms. Lewis, null pros is a fancy Latin way of saying get rid of or dismiss. So what Mr. Miller is doing is exercising his discretion and exercising it in a compassionate and wise way, saying that he believes there is evidence that he could use to prove that you took something without paying for it, but it was not a lot of money worth, and it was baby clothes. It wasn't gold watches and diamonds. And given the age of the case and the circumstances in your life, he's dismissing the charges. So if there's nothing else holding you, you will be released. I don't know if there's anything else holding you. Ms. Rios doesn't think there is. If the only reason you're in is this case, then by this time tomorrow, you ought to be out. Do you have a place to go?
Yes, I do, Your Honor.
Good. Well, you should go there when you get out.
Okay.
All right? No more shoplifting.
Okay, thank you.
All right. Thank you, Mr. Miller.
Thank you, Your Honor.
All right, so let me just take a survey of where we are. We have taken care of the final plea calendar. We're going to figure out if we can get Mr. McCrary on Zoom, if he's not downstairs, if Deputy Gordon lost him. We still have 2 revocations, Harvey and James. The possibility of resolving things with Ms. Brown, given the increasingly generous state offer, where the conditions would be the wonderful services she's already availed herself of. I think that's it. Are there other moving pieces? So if we get back together 1-ish on that clock, that work?
It does.
Okay, excellent. Let's try that. Thanks. We're gonna go talk with Deidre about your fumble. All right, Ms. Williams, you should come back too.
Yeah. Oh, reset, we just, so, yeah, let me reset. That, James, yes. Yeah, so we don't need to come on. He's gonna come on. Yeah, so just, I'll make the announcement, and then, can I talk to Harvey really quickly again? On the, so. You got that's one. So.
You're going that way? Okay.
Oh, I don't.
No, go that way. I'll be there in just a second. You're good.
I really saw.
Sorry for the delay. Ms. Williams and I were talking about how hard it is for a defense attorney to confront a client with, gosh, you are real guilty in this case, and 20 years is the best I can get you on this one. How that conversation would work. Of like, trial could mean life without parole. I can get you 20 years. And how do you navigate a discussion like that with a client? I don't have that power. But there are impressive attorneys who are able to make that connection and build that level of trust to walk someone along that path. But that's not what we're dealing with today. So McCrary is tomorrow. Is that the best you can do, Gordon? Okay. And we knocked out Toussaint. So Ms. Brown, what's our update on Ms.?
Not gonna happen.
Not gonna happen? Do I need to chat with her again or?
Send you some stuff.
Pardon me?
I'll be sending you some.
Okay, so she's good-ish for now. All right, and we're not squeezing another no pros out of Mr. Miller. He's out? Okay. All right. So we need to, I guess she's basically just back on a calendar. It would be, we need to, I'll work with Ms. Nelson, but it's an open case, so we need to kind of get a scheduling, or do you have discovery?
I do have discovery. I went over it with her. It's only 2 pieces.
Okay.
But
all right. So what would you like it reset to a final plea date?
Probably an inquiry.
Inquiry? Okay. All right, we'll do that. Reset to inquiry. So gosh, is it just then the probation revocations? All right. Is Capri male or female? Male. Mr. Harvey has a bunch of folks here, so let's do that one first. I'll try to be oblique in talking about what this is about, unless he just is open about it. Okay, you know. Okay, all right. He's a big kid. What did Ms. Simpson send me about this?
No. I mean, you can ask, but I know what the answer will be.
Crystal ball. All right. Ms. Rivers, good afternoon. You ready to go?
Yes, I am. Good afternoon.
Great. Then we're going to get on the record with position 1 from our revocation calendar, which is 13 SC 118641, State versus Harvey. Mr. Harvey is here in court. Good afternoon, sir.
Good afternoon.
With Ms. Wood, his lawyer, and Mr. Harvey, you are on probation for robbery and aggravated assault. You must have received a whole lot of probation because this is an old case. I think I was a judge back when this was sentenced. I wasn't the one who dealt with it. It must have been Judge Downs.
Yes, sir.
But importantly, you've got 2 years and 3 months-ish left on your probation. And in May of last year, I signed a warrant that alleged that in January of last year, so just about a year ago, you committed an offense in Fulton County, a misdemeanor about indecent exposure. And that's a basis to revoke probation. So I signed that warrant in May, and I guess you got picked up a month or 2 ago for something, but that triggered this warrant. And so we need to work through that today. Ms. Wood, is Mr. Harvey admitting to the violation or stipulating, or what's our posture?
He's admitting to the arrest, Judge.
Okay, what's the status of the case?
Yes.
It's an unindicted, but it's going to Superior Court.
Well, there's So there's actually, I think there's two separate situations, and then one of them's in state court with a bond, and then there's a PI that also has a bond set.
What's the PI number?
25 PI 008645.
So that's a whole different situation. Is that part of a petition? Because that's not on the warrant. I don't want to. It's probably in your email. Let me open the petition. Okay. Got it. So the petition is updated. So it's got that same thing I mentioned about the January of last year Fulton County thing. Oh, then you had a second one. And then in October of last year, you got arrested for drugs and a gun. And violation of the rules for operation of personal assistive mobility devices.
Scooter.
Oh, you were on a scooter, supposedly. Don't admit to it, but that's what okay, I've seen that before. That's what the PI is all about.
Yes.
Got it. Oh, and there it is, personal assistive mobility device. So drugs and scootering in October, and then a couple public indecencies earlier in the year. That's all in the petition, and he's admitting to being arrested for all those things.
Yes.
Okay, that's a lot of stuff. What is your thought about how we handle those admissions?
Yes, Judge. So he has been in custody here with us for right at 80 days today.
Yeah.
I am asking for a revocation of 6 months in addition to those 80 days, which would be almost 9 months revoked. I will let the court know, he does have a Tatnall County hold for a probation matter. His family shared more with me about that. It sounds like it's some technical stuff, but that is in the system. So I'm assuming he will have to go deal with that when he leaves here. Judge, he's 33 years old. He has 3 children that he's very involved with, ages 15, 13, and 3. He was released from Department of Corrections in 2021, I believe. He's been working at FedEx and Lowe's in between that time, just trying to keep everything on track, Judge. And like I said, he is admitting to the arrest, but not to the whole case. So he will work with that PI case at a different time. So we're just asking for the 6 months revoked, Judge.
Okay. Ms. Simpson, is this Mr. Harvey's first revocation since he's been on this sentence? It looks like it.
Yes, it is.
Okay. I'm just looking for the final disposition. Whoops.
It's incorporated into the Department of Corrections.
Oh, look at that. So you got 8 years to serve, and it was to a robbery. So you did it. How long did you serve?
The whole 8.
You did the whole 8.
Yes, sir.
Okay. So that would be getting out in 2021. All right. 15 to serve 8, 7 on probation. Did you get your GED while you were in prison?
We stayed down a lot. We stayed locked down a lot, so I never got a chance.
Okay.
We continue getting.
All right. So 6 months prospectively. I don't want lots of details, but it is going to make a difference. The public indecency can be, I need to go to the bathroom, versus there's a 3-year-old girl and something happens. Do you know much about either of those?
I don't. I was more concerned about the PI case, Judge.
Okay. It probably is more problematic for him as well. Yeah, that was the other thing I noticed. Your view is to maintain the first offender?
That would be my request, Judge.
Okay, all right. Mr. Miller, your thoughts about how we handle Mr. Harvey's situation?
Your Honor, it appears that he has, it's my understanding, he has 2 years left under this sentence. Your Honor, given the 2 open cases, the state would ask that first offender be taken and that we revoke the balance on this case. I also would ask if the court is able to add an extra condition in which he has to complete a GED.
Okay. So if I revoke the first offender status, then I need to resentence him. It's not just take it away, but it would be resentencing him. Obviously, he gets credit for everything he's already done. The most he could get for the armed robbery was reduced to robbery, so it was a 20-year range. And he served 8 years, plus he's done a bunch of probation. So I need to work through what the math would be, but I just want to make sure I'm following. Your recommendation is to revoke the first offender status and resentence Mr. Harvey. And I guess your math might be sentence him to 2 years to serve prospectively with no probation after that. That would sort of be the same as revoking 2 years.
Yes,
Okay.
that's correct, Your Honor. With the added condition that he obtained his GED.
Okay, got it. All right. Ms. Simpson, what is the Department of Community Supervision's view as to what ought to happen here?
Judge, I have an inbox of the state in the matters of revoking his first offender status. This Tattnall County sentence probation extends hours.
What is the case out of Tattnall County?
It is for a penal institution charge and criminal damage to property in the first degree.
So it would have been something that he picked up while serving his prison sentence. Got it.
And that probation time does not end until 2037.
Okay. So this case really can be moved to the side. Understood. Okay. Mr. Harvey, anything you want to add?
Yes, sir. I just want to say that I know that I had a lot of probation, but I'm a changed person. I got a family to feed, and like I got a 3-year-old kid, son, and another son. I don't think I should be able to go do all the time. I know I'm a good person, but I ain't mean to do what I was doing. So it just, I feel like 6 months would be good, and I could take all the class or whatever probation. I mean, classes. I can go do, what is it?
GD.
GED. I can do my MR. They say MRT. I can do a community service. I can do whatever. I just don't want to go back to prison.
Okay. How many kids do you have?
3, sir.
3. And what are their ages?
15, 13, and 3.
Okay, so you had 2 before you went into custody, and then you must have had one like right after you got out.
Yes, sir.
Okay. So the 15-year-old and the 13-year-old, are they both in school now?
Yes, sir.
Are they local in the Atlanta area?
Yes, sir.
Great. How are they doing?
Doing very good.
Okay. Is the 15-year-old a boy or a girl?
Both boys, 13 to 15 boys, and a 3-year-old a girl.
Okay. And where are they in school?
One go to Maynard Jackson, and the other one go to Highlands.
Where's that?
Like the old Kennedy, like by James P. Brawley. Like,
Okay. And then 3-year-old's too little to be in school right now.
she go to school too.
Like some kind of daycare-ish thing. Yeah. Okay. Well, good. All right. Well, Mr. Harvey, you've got a bunch of business you need to take care of. Tattnall County needs to see you, so that'll be your next stop. And then you've got the unindicted drugs and gun case here in Fulton, plus the 2 misdemeanors that are going to be following you around for a little bit. I think it does make sense to close out the 13 SC case the robbery from long ago. I am going to revoke your first offender status and resentence you. What I'm going to do is resentence you to, oh, I got to pull that back up. Give me a second. So count one was reduced to robbery. It'll stay reduced. I can't change that. And I'm going to sentence you to 9 years to serve on that. Count two will be 9 years to serve. And then count three will be 5 years suspended. Counts one and two run concurrently with each other, and count three runs consecutively to count one. So it's a total sentence of 14 years to serve 9, with the balance suspended. And the only condition of your suspended sentence is that you obey the laws of Georgia, the other 49 states, and the United States. And that just means that if you were to get in trouble after you get out, and the state wants to try to convert those suspended years into more jail time, they can do that. But it's not probation. You're not under supervision. But that third charge you had, which was possession of a firearm during commission of a felony, has to run consecutive to the others. You're going to get credit for the 8 years you've already served, along with whatever time you've been serving since you got picked up, because it's all connected to the charges in this case. And then that case will be closed out. Ms. Wood, any questions about that?
I just want to make sure, Judge, on, I'm sure, I think it's been a long time since I've done a resentencing. It'll be like an updated final disposition.
It will.
correct?
I'm looking at the final disposition now. It'll look a little different because the form has changed.
Okay.
Well, this one, the older version, you had a resentence box. I don't think it'll be, we'll make sure it says resentencing, because it won't be first offender anymore. And it will reflect the fact that he served that other time. Obviously, the Department of Corrections needs to bless it, but that's clearly in their records, because it's not that Mr. Harvey was in some other county. He was with the Department of Corrections.
Sure. I just wanted to make sure I didn't need to get any, since it is Department of Corrections, I didn't need to get any type of documentation for that.
I don't think so, and I'll make sure that in the,
Well, his, time that they're custodian, they already have that, so they're already aware of his original.
yeah.
Right, time, sir.
Okay.
And I'll put that in the for courts use box as well, that this is a resentencing. And so all the time that Mr. Harvey has served in connection with this case is credited towards those 9 years.
Doing the sentence.
Mr. Miller, anything else in connection with Mr. Harvey's case?
No, Your Honor.
And I'll go back and talk to you about it.
All right. Any questions?
No, sir.
All right. Good luck with things.
Thank you, sir.
Can you hold him till after the game?
Are you handling Mr. James?
Yes. This one is negotiated.
Okay. I have the warrant. Is there anything different on the petition? I'm sure you sent me the petition. I always,
That, violation is, petition.
oh, it was the wrong crime.
Yes.
Right. So you sent that.
That the actual violation is, he was arrested on November 8th of 25 for aggravated assault, 2 counts of felony battery.
Is it on the petitions? Because I've got the petitions right here. It's not. Oh, because the petitions match the warrant.
This was always brought to my attention when I went to serve in this position this morning.
Got it.
And so I had to write down the charges from the indicted case. I do have.
Okay. Oh, right. This is the one that it really, we could send this to Judge Leffridge, but we're going to handle it here.
Yes.
Okay.
Now also, he has a third case for
Okay. What case number is that?
It's 14 SC 127 866. That one is original with Judge Mack.
Okay. How much time is left on that?
13 years, 2 months, 6 days.
Dang, okay.
It was originally by Judge Mack.
Judge,
You heard.
yeah. 2 years, 2 months. Okay, and the actual charges are of this new case?
Aggravated assault, 2 counts of felony battery, counter violence, and then there's a misdemeanor battery, counter violence.
What's the case number?
25 SC 007918.
It's gotta be one of the last cases of the year.
And then the rest of our patient. Well, he's already done it. So there it is. Just 1 year. Yeah.
No, James.
Yes. This security can't go by. What? I think it was confusing, named. Okay, cool. You took a phone. Or did you right here?
It's a phone.
Yeah, just whatever your best number is, so I can give it to probation.
All
Thank
right,
you.
let's get on the record with Mr. James. It is 3 cases, one not on the calendar. It's 22 SC 180803, 23 SC 186244, and then the old one, 14 SC 127866. Good afternoon, Mr. James.
Good afternoon, sir.
Mr. James is here in court with Ms. Wood. We've got Mr. Miller for the state. And Mr. James, there's been a little confusion about your situation in that, for whatever reason, the warrant that I signed and the petition that was issued in relation to revoking your probation listed the wrong charges for what you more recently got arrested for. In fact, let me pull up that case again. Where'd it go? So what we were moving forward on was this understanding that you, in October of last year, had been arrested for terroristic threats, having a gun, and having some marijuana. But it turns out actually what you got arrested for was an aggravated assault and family violence battery involving Ms. Martin from September of last year. And that's the basis for any revocation that we might handle today in the 3 cases for which you are on probation. Ms. Wood, have you talked to Mr. James about the confusion, not that you had or that he had, but that sort of moving along with the warrant and the petition?
Yes.
And are you comfortable moving forward with an orally amended petition that cites as the basis for any possible revocation the fact that Mr. James has been arrested and indicted for the September 23rd situation?
We are, Judge, and I think a revocation order would likely clear it up as well, correct?
Well, we'll make sure it clears it up, but
Yes, we are.
one response would be, I'm not ready to talk about that. I was ready to talk about this October 2025 terroristic threats because we were going to deny it and there'd be no revocation because he didn't do that. All right, then we'll go forward with the basis for any revocation being the arrest for an indictment for the aggravated assault. Mr. James, you've got a little less than 3 years left on one of your cases, a little more than 2 years left on another case, and then your old case from 2014, you still have 13 years left on that. That was a big old sentence you got in that case. So we need to work through all that. Ms. Wood, what are you recommending?
We are recommending to revoke 60 days and reinstate to probation.
Well, to terminate the balance.
Oh,
14.
yes, that's right. Thank you.
To terminate the balance, the 13-year balance? Okay.
Reinstate the both cases on calendar and terminate the balance to 14 and case.
All right. Mr. James was revoked once on the 14 SC case in April of 21. So it would have been before either of these two cases. He got a 6-month revocation. That's the only revocation I found. So with one prior, what was the basis for that? The order from Judge Newkirk simply says stipulated to violations.
I think for the original. He had an arrest in December of 2019 for battery and arson in 3rd degree in East Point. And then he had an arrest in May of 2020 for aggravated assault and 4 counts of undamaged property and 2 counts of possession of firearm by convicted felon and a technical.
Okay.
Is that a 1 or a 6?
Got it. Thank you. Mr. Miller, what is your recommendation as to Mr. James's situation?
Yeah, the state agrees with the defense regarding the recommendation of reinstating the balance of the 2 matters that are on the calendar today and closing out the 14 SC case. Reason being, Your Honor, is that the victim of the underlying case, that case number ending in 7912, Ms. Martin was here in court today. She did provide the state with a statement that was notarized indicating that the matter in which brings us Mr. James to court was somewhat played up by her, that she initiated it, she started it, and that she wanted to make sure that the state had this information. The state did provide this document, also a copy of this document, to the probation officer as well.
Okay.
Ms. Martin did leave at the break, Your Honor, but I do have that document here.
Okay, but you met with her, she was here, she took time out of her day to try to clear some of this up.
Yes, Your Honor.
Okay. The allegations are for the open case that serves as the basis of the revocation, a strangulation, but also one where there was visible bodily harm, the swollen eye. So it sounds like that part, I mean, if the officers are seeing it, you can't hype that up too much. But the other parts, in theory, are susceptible to, and a braid detached from scalp. But okay. Is Ms. Martin someone you had an opportunity to speak with, Ms. Wood?
Yes, Judge.
And what's the gist of what she shared with you?
Same as what she shared with the state.
Not that nothing happened, but maybe it's not as bad as it looks in the indictment.
Correct, Judge.
Okay.
Well, and again, just to clarify, she provided the state information indicating that she was the initial aggressor. She started it. She came at Mr. James, and in defense of himself, those injuries were inflicted on her. if anything. Now, she did not admit to any injuries to me, but she did say that he responded to her in kind in order to defend himself.
Okay, got it. Mr. James, anything you want to add to the discussion?
No, sir.
How long have you known Ms. Martin?
Since 2019.
Okay. Oh, I guess you have a kid, at least one kid together.
Two.
Two kids together. How many kids total do you have?
4.
Okay. Well, Mr. James, excuse me, I find that you did violate the terms and conditions of your probation by getting arrested and indicted for the aggravated assault and family violence battery, 2 counts, swollen eye and torn braid of Ms. Martin back in September of last year, so just about 3 months ago. Getting arrested for that is inconsistent with what you need to do on probation. You were on probation for 3 cases. What I'm going to do is revoke 90 days of your probation. And in the case ending in 803, I will reinstate the balance. In the case ending in 244, I will reinstate the balance. And then in the 14 SC case, that's ending in 866, are we suspending or terminating? I think we terminate that case. Following his completion of the revocation, that case is terminated. That's the one with the real long, you had 13 years left on it. And I agree with the notion that we close that chapter. We tend not to do 15-year probated sentences these days, absent extenuating circumstances. And looking at that case, I don't see a need for that. So we'll close that case out. You'll be on probation for the other 2 cases. And of course, you still have this open case with Judge Lethbridge, and you'll need to continue to work through that. What's next on that? I don't see anything on that.
It's my understanding there's a bond hearing, Your Honor, regarding that matter this Thursday.
Okay, you don't have a bond in that case yet, or the bond's too high?
I don't have a bond yet, sir.
Okay, oh, yeah, look, bond was denied in November, so, great. I hope you have a court date soon. I'm not seeing it in here, but it's not my docket. But as long as you understand, we're not resolving that case today. We're resolving the fact that picking up that case was a violation of your probation. Does that make sense?
Yes, sir.
Okay, all right. Then you're not going to see me again unless there are other issues on probation, but you will see Judge Lethbridge, who's right next door. It could be as early as this week to talk about bond. Sounds like you've hired Mr. Hudson. Is that right?
Yes, sir.
All right, he'll be there. He'll let you know what's happening. That's it.
All right, thank you, sir.
Do you need your probation officer's contact information?
I have. Yes. Thank you.
On 03, 44, and 66. Yeah, but 66 we then close out. And with that, I think we have finished things. Nope, Ms. Rio's still here.
Okay. No, just going back to Broderick Davis, because he texted me right after court. I sent you the email, Ms. Nelson, because he texted me right out of court, showing me a screenshot of the victim texting him. And so he was like, what am I supposed to do? I emailed Ms. Willingham. She called the victim, and the victim now wants no violent contact.
Oh, okay. Well, I haven't signed his final disposition. So, and Ms. Willingham told you, can you just forward that
I
email?
forwarded to Ms. Nelson.
Good.
I just did.
All right. If she's got that, then let Mr. Davis know that the final disposition will have no violent contact with, I think this was Ms. Hernandez?
Yes.
Okay.
With that, though, can we now steal it on the front end? Because was that the only reason we couldn't?
So yes, if there's a TPO out there, that needs to be withdrawn because he can't have contact with her, violent or not, if there's a TPO.
Okay.
And maybe that wasn't, we had a bunch of cases this morning.
TPO, I think she was saying this constitutes as something if she needs to have the disposition to go get a TPO.
To go get one. Well, why don't you confirm
Okay.
and confirm with Ms. Willingham, is there a TPO? Because if so, don't we need to get that set aside or withdrawn? Answer yes. If there's not one, then it could be Ms. Beza was doing exactly what you said, which is if you lock it down now, what if we need to get a TPO?
Okay.
And I think, this is, no, you don't need to. What she said was the way Ms. Hernandez could enforce the no contact is by having the final disposition. That was going to constitute the TPO, but now it's not going to say that. So yes, send me sealing information.
Thank you.
Wow, real-time changes here. Okay, you're welcome.
I guess that is all now.
Now that's everything. So we've got a trial calendar tomorrow. Hopefully there's been a little progress with working some cases out. Mr. Miller, will you be here or Mr. Sperry or TBD or back and forth?
TBD, but I can say that I believe Ms. Smith will be here.
Ms.
Smith.
Oh, okay.
Smith will be here with a combination of either me or Sperry.
Okay. However you want to work it. I just want to make sure, I don't think you and I have done the trial calendar call piece, but I mean, it's chaotic. There are gonna be a million people here. They're all gonna want to talk to a prosecutor. And that's not me, but it's you. So as long as there is someone here, Smith, Sperry or Miller would all be great because the three of you all know about the cases. So super. 9 a.m. We'll get rolling with that.
Okay.
All right. Thank you.
Wheelchair. Your mailbox up.
Yeah.
I mean, with final dispose? Yes, that's great. Those are happy emails. All right. Thank you, Ms. Jackson and Ms. Rivers. I will see you both tomorrow. We've got at least a few pleas off the trial calendar that we'll knock out in the morning.
Thank you. Have a great one.
All right, you too. Bye-bye.